Mr. Knight, state your full name for the court.
Someone listen.
Hey everybody, so welcome to the Courtroom Files Live. Happy Thursday. So I actually started this stream like 3 minutes ago, and for whatever reason, YouTube did not pick it up right away. So we're with Judge McNally. You missed my normal opening. So sorry about that. This has just been one weird week with glitches and all sorts of things, but I'm happy to have you all here. Happy Thursday. Let's get on with the show.
Chandler. Brandon Scott Chandler, file 25T645681. Morning, sir. Your name?
Brandon Chandler.
You're charged with driving on a suspended license. I can arraign you and let you go talk to the prosecutor, or I'll give you a lawyer, whatever you prefer.
I'm not really sure. I should ask my mother.
If you're in doubt, get a lawyer. Let's give you a lawyer, okay? Go get the lawyer. Out in the hallway, you'll talk to the lawyer will talk to the prosecutor, then you'll come in, okay? All right, with the lawyer, thanks. Is there anything else down there? This is moving like a snail.
There's the no-shows from yesterday.
Yeah, let's do them.
These are from yesterday.
Matthew Glenn Malone, 25B148976. Mr. Malone failed to appear yesterday. We're going to issue a show cause. People against Brianna Ray Barnier, 25B148694 A and B. On the A file, defendant failed to appear yesterday. We're going to issue a show cause. And on the B file, same thing. Show cause to issue on both of those. Prepare to appear. Marlon Amir Owens, 25B149007 A and B. This is indecent exposure, telephone harassment. Defendant failed to appear yesterday for arraignment pretrial. We're going to issue a show cause per requirements of the statute. Jordan Cornelius Adkins, 25B147641 A and B. On the B file, defendant failed to appear yesterday. That's a civil infraction default judgment. And on the other file, warrant issued, about his third miss, 5,010%. And by the way, for the record, the default judgment it entered back on March the 26th. I don't know. So now 5,010% isn't enough. Is that enough misses? 7,510%. People against BSC Investment, 24B147019. Mr. Butler failed to appear. We issued a show cause. This is 24B147019, BSC Investment. They failed to appear February 3rd. And then we issued a show cause versus the company. And we are going to issue a warrant because we show caused Mr. Butler, the president or owner, bench warrant to issue versus Kenneth Butler. I think you should give a call over there, Lisa, or I will have Tabitha, 353 cash or surety. Tell them the warrant's been issued for the arrest of that individual. Jackson, Jalen Keyshawn Jackson, 25B148633 A, B, and C. On the A file, one failed to appear, also failing to appear before. 3,010% warrant to issue, bond to be forfeited, and on the B and C files, the defendant was already defaulted on those civil infractions back on June the 18th. Bryant Allen Kinney III, 25B148464, defendant failed to appear. This is a indecent exposure charge, 4,010%. Failed to appear for show cause before, and then failed to appear today. Warrant issue, 4,010% will be the bond amount. Matthew Glenn Malone, 25B148493. Defendant failed to appear, 3,010%. Frank Joseph Renna, 25B148513 A, B, and C. On the B file, I'm going to issue a warrant, 3,010% on the, that's for the second miss. On the A file, 2,010%. And on the C file, a default judgment was already entered on July the 2nd. Antoine Leishon Torrance, 25B148 681 A and B, 3,010% on the A file. On the B file, the defendant was already defaulted when he failed to appear for the first hearing on July the 2nd. Anything else? I'm sorry?
Well, there's a bit of pause in the action. Good morning once again, everybody. Welcome to the Courtroom Files Live. So yesterday we did a little bit of nature. Today I have a different view for you. This is the Osprey cam from Loch Arkaig, brought to us by the Woodland Trust. So very cool. Just thought I'd show you that. We'll check in on these nice birds from time to time today. Let's stay in Michigan, but let's go over to Judge Simpson and say good morning to him. He's running his PCC docket today.
Given the waivers, the court will consent to hear the matters. The court does call the case of the people of the state of Michigan versus Ronald Fleming.
Good morning, Your Honor. Ashley Lundy for the people.
Stephanie Cannon on behalf of Mr. Fleming, who should be appearing via Zoom. Yes. Mr. Fleming, could you state your name for the court?
Ronald Fleming.
Thank you. Your Honor, today's the date and time to go over the competency evaluation, or I'm sorry,
Competency review.
the report. And the report has been provided to me. I do believe the prosecutor has a report.
I received it, Your Honor.
And in the report, it is indicated that my client is not competent, but they do believe he can be restored to competency within the statutory time frame. So, Your Honor, we are asking, we will stipulate to those findings, and we are asking for another hearing regarding competency.
And Your Honor, I'm sure the court recalls we've been pending competency for quite a while on this file, but the defendant, I do believe, was admitted to the forensic center in June. So he's been there now for about a month and a half. So I'm optimistic that we may actually be able to get the treatment restored and done at this point. I would request also an adjournment and would stipulate to the findings in the report as provided to myself, defense, and the court, and ask the court to continue the order for his treatment and allow him to attempt to regain competency.
And just so that we're all clear, the report that I'm looking at is the July 15th report. She needs this.
Yes, Your Honor.
Yes, Your Honor.
All right. Based upon that report, the findings are, and it's been stipulated to by the parties, that the defendant still remains incompetent to stand trial at this time. The court will then continue that finding. And I will set a review hearing. Give me 90.
October 16th.
October 16th, 2025, 9 a.m.
Thank you very much, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you, Mr. Fleming.
Thank you.
Court calls case People versus Tariq Wilson.
Stephanie Cannon on behalf of Mr. Wilson, who should be appearing via Zoom. Mr. Wilson, could you please state your name for the record? Mr. Wilson, could you state your name for the record, please?
Mr. Wilson, can you hear us? Not sure if he can hear us or not. I heard, huh?
I can try again.
All right. I'll pass him. Hear us. Court does call the case, People versus Carista Riopel.
Good morning, Your Honor. Requesting permission to pursuant to Michigan Court Code 0 under the supervision of this attorney Ashley Long.
Oh, really? Okay, permission to practice is granted.
Thank you, Your Honor. Christina Berg, hearing for the people.
Morning, Judge Mike Gaddy, Assistant Public Defender on behalf of Ms. Riopelli, who is here via Zoom. If you could state your name, ma'am.
Carista Riopel.
Your Honor, I have had a chance to speak with Ms. Riopel, and we are asking to adjourn this matter so I can visit her and go over the mitigation information that we have prepared. I'd like to do that in person with her. So I'd ask the court for a couple weeks adjournment so I can accomplish that.
So you want 2 weeks or 3 weeks out?
Maybe 3 weeks, Judge.
August 7th. I think it's okay. Probable cause conference will be adjourned August 7th, 2025, 9 a.m.
Thank you, Judge.
Thank you.
Continue. Thank you. Court calls the case, People versus Amanda Stardutz.
Morning, Your Honor. Gloria Berg, Assistant Prosecutor of Cleveland on behalf of the people.
Good morning.
Good morning, Your Honor. Kerma Dadush on behalf of Ms. Skardautis. Ms. Skardautis, can you please say your name for the record? Oh, she's not unmuted.
I don't know if she can. Where is
Amanda?
she? She's at MDOC.
Can you try to see if someone can unmute you at MDOC?
You're trying to force it. Oh, we got it. Ma'am, can you state your name, please?
Amanda? Can she hear us? Amanda, can you please say your name for the record?
I don't know if she can hear us.
Hmm.
Yeah, but she's not responding. They're at different facilities, correct?
No.
Yes.
Oh.
The two that couldn't hear me, because I got two
Oh.
that are unmuted but cannot hear me. All right, I'll pass that matter.
Thank you, Your Honor.
You'll contact or try. Court does call the case, People versus Mariah Thomas.
Kerma Dadush on behalf of Ms. Thomas. Ms. Thomas, can you please say your name for the record? Same. Okay.
Ms. Thomas, if you can hear me, if you can wave your hand, I would appreciate it. Yeah, I'm not getting.
My name isn't Miss Thomas.
Oh. Yeah, I was gonna say, I don't think that's her.
Okay,
No.
what is your name, ma'am?
My name is Anitra Coomer.
Got her.
Judge, she was adjourned via step.
She was adjourned.
And Ms. Coomer, just for you know, I'm coming to see you on Monday. I have.
Okay.
Yeah.
Okay.
All right, sorry about that. I
Okay.
guess it was adjourned
That's
via
fine.
step. Thank you, ma'am.
Yeah.
Maybe they can put Amanda in there.
Pardon? So do we have Miss Thomas?
I thought that was Miss Thomas because.
Yeah.
Yeah, so no, we don't have.
Okay. This is going well.
Well,
So you want to adjourn that out?
well,
Was she,
Miss Thomas's?
pardon?
No.
Is Miss
Ms. Thomas is in the NVOC, dates of behavior at 11, when that facility signed.
Oh.
I just thought they signed it early. I can come get it.
Okay, so she's at 11.
Yes.
We are adjourning Amanda. I think she'll stay here name for the record anyway.
She does.
Okay, thank you.
Well, I have to make sure it's her too.
I believe that is her.
Amanda? I just don't know why we don't have. That's it, Huron Valley.
Yes.
See if you can get through to them. Court does call the case of the People versus Donnell Young Senior.
Good morning, Your Honor. Jeff Green, Special Assistant Attorney General, here on behalf of the people.
Good morning.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Young, who's here to my right. State your name, Mr. Young.
Donnell. What are we doing?
Your Honor, I did have a chance to communicate with Ms. Williams from the AG's office. At this time, Mr. Young would like to set this matter for the preliminary examination.
All discovery is complete.
Yes, Your Honor.
The people have their witnesses available the 29th.
29th, yes, Your Honor.
Preliminary examination in person, July 29th, 2025, 9 a.m. That's before Judge Barr.
One thing, Your Honor.
Bond will, thank you. Bond will continue.
Thank you, Judge.
Your Honor.
You have a question, sir?
Oh, yes, Your Honor. I just wanted to make sure that we repeat it again on the record that we've made a pre-preliminary exam offer. And as of the date of the preliminary exam, we'll be withdrawing that offer. Just want to make sure the defendant is very clear about that. Thank you, Your
All
Honor.
right. Understand
Yes,
that.
yes, we have gone over the offer, Your Honor. It's the people's, I don't want to say standard, but the offer that they generally make.
Okay. And you understand that if it proceeds to prelim, it will be withdrawn.
Yes, sir.
All right. Very good. Thank you.
Thank you. Good morning, Your Honor.
Thank you. You too, sir. Court calls the case, People versus Hector Gonzalez.
Prisoner hearing for the people.
Morning, Your Honor. Michael Vincent on behalf of Hector Gonzalez.
Good morning, sir.
Mr. Gonzalez, put your name on the record. Hector Gonzalez, Your Honor.
Thank you.
Your Honor, today's date, time for probable cause conference. We wish to have a prelim exam on this matter.
All right. All discovery is complete.
Yes.
We'll have their witnesses available the 29th. Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Washington. Who are you? No, I'm kidding. I'm kidding. I just haven't seen you in a while. I didn't recognize you. The 29th is not. Any objection from the people if I go to the next date?
We're going to check to make sure he's there. Okay. Just make sure. Yeah.
Set preliminary examination August 5th, 2025, 9 a.m. before Judge Freshour. Bond will continue. Thank you.
Thank you, Your Honor. Thank you, Your Honor.
Court does call the case of the People versus Jessica Hafner.
Your Honor, after that order requesting permission to stop this under MSR 8.120 under the supervision of AG.
Who? He has an intern?
Yes, several.
He does?
Very good.
He's not old enough. All right, permission to practice is granted.
Thank you. I've got a nice phone report.
Thank you, Your Honor. Today's the date and time set for probable cause conference. We are just asking for a brief adjournment at this time. The court should have the.
Did you state your appearance?
I'm sorry, Judge Cabral on behalf of Ms. Hafner. Ms. Hafner, please state your name for the record.
Jessica Hafner.
Thank you.
Judge, we're just asking for an adjournment.
You're looking for an adjournment of this?
Yes, Judge.
All right. You want the 31st or the 7th?
The 7th? The 7th, please.
Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thanks, Judge.
Wait on the hallway for me. I can talk to you.
Mr. Wilson, can you hear me, sir?
Yes, sir.
Okay. I think something happened the first time, so let me call your case. Court does recall the case of People versus Tariq Wilson.
Stephanie Cannon on behalf of Mr. Wilson, who is appearing by Zoom. Mr. Wilson, could you please state your name for the record?
Terry Wilson.
Thank you. All right, what are we doing?
Your Honor, I do believe I turned in a German form on this. When I attempted to make contact with him, MDOC let me know that I had to go through a lengthy process. I've started that process. He can add me to his phone call, to his visitations, and I should be able to speak with him. But in the meantime, I have filled out the application, turned it in, and I'm waiting to get approved as somebody who can come to the jail. So I'm asking for an adjournment. I do believe I asked for a 3-week adjournment because of the process.
That objection, probable cause, August 7th, 2025. Thank you, sir. Court does call the case, People versus Rahman Mohammed.
Good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
Connor on behalf of Mr. Rahman. Mr. Rahman, please say your name for the record.
Rahman Mohammed. All right.
And Your Honor, we will be waiving the preliminary exam today. I have a form I'm going to ask Mr. Mohammed to sign. All right.
And sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses are committed and that you committed them?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Your turn.
Judge, this time, waive formal reading, stand mute.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
with Judge Cummings.
July 29th, 2025, 1:30, Judge Cummings.
Thank you, Judge.
Thank you. Bond will continue. Lee, can you sign off on it? Court does call the case of the People versus Matthew Brown. Matthew Brown?
Yes, I am here, Your Honor.
Correct. Ms. Constantino? For some reason you can't get through.
Sorry, Judge. I hit the wrong button. Good morning, Your Honor. Christina Costantino on behalf of Matthew Brown.
Hey, good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
All right.
And Your
And
Honor,
what are we doing?
Your Honor, I was just recently appointed to Mr. Brown's case, given that we would be asking for an adjournment of the probable cause conference.
All right. Probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond will continue.
Thank you very much.
So yeah, Michael, you raised a very good point in the chat a little while ago. Nobody seems to adjourn like Judge Simpson adjourns. It's just never ending. Let's switch it up a little bit. We'll go to Texas. We'll say good morning to Judge Stevens.
CR 764 with State of Texas versus Jimenez. You were Mr. Jimenez? You have to speak out.
Yes.
Good. Thank you. And you were here with Charlie Rojas, your attorney, very good man. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
We can hear
In summary, workout. John. In summary, this indictment alleges that on or about March 7th, 2023 in Jefferson County, Texas, you committed the second-degree felony of illegal possession with intent to promote child pornography. So illegal possession of material that is depicted as child pornography. And this is a second-degree felony. Do you understand what you were charged with? If convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand, sir?
I do.
An agreement has been reached. Whatever sentence shall not exceed a cap of 6 years. So that means you are looking at different options here. No less than 2 nor more than 6 years imprisonment could be assessed. You could be placed on deferred or unadjudicated probation for up to 10 years, where you would not be found guilty so long as you follow the terms and conditions of probation. And regular probation is also an option here, isn't it?
Yes.
So you could be sentenced to no less than 2 nor more than 6 years confinement in prison. Then that confinement could be suspended and you could be placed on regular probation. Those are 3 options. And what we're going to do is order a pre-sentence report. That takes a few weeks by the probation office. Then we will bring you back for a hearing. All parties will have a chance to add additional information they wish. And then you can be heard and then I will make the decision. That's going to be the plan. Do you understand, sir? If I follow this agreement, you have no right of appeal of your case. Do you understand?
I do.
How do you plead to this charging you with this second-degree felony of possession, illegal possession with intent to promote child pornography? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
I do.
Show you what marked the State's Exhibit 1 there, sir. Did you sign that document voluntarily? You have to speak out so she can hear. Did you understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what is on that screen? That is interesting.
That's from, I think,
It's courts.
Norway or somewhere. It's
It looks like something in space.
Find out, like. Hold up, yes, sir. I thought it was.
You understand what you're charged with? The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this states true, so help you God. Correct? Yes?
Yes.
Okay. State's Exhibit 1 is made a part of the record for all purposes. We're going to hold this in suspense, and we will return back later after a pre-sentence report is prepared by the probation office. All parties will be able to return. What is the date we will have the hearing for sentencing?
8/28, so the PFI can get done.
August 28th is tentatively set. Okay, please see the probation officer. Thank you, sir.
And Thursday.
Also, there's one other case that will be dismissed as part of this agreement if this is finalized. Who's next and ready? And
Everest.
is Gallo ready?
No, sir.
Everest.
Who?
Oh,
Santos, Navarez. And Los Navales. See that lady? Thank you.
Okay, well, they line up the next contestant. Let's do this. Barbara, since you're fuming a little bit, and I don't blame you, stare at the pretty birds, do a woosa or two, and try to relax a little bit. Because I agree, this stuff sucks. People are so broken, aren't they? And some, quite honestly, especially these people who are into kids, they're broken in ways I don't think can be fixed. Okay, let's go back to Judge. Okay, Judge is muted. He does that a lot. He gets on the mute button and then forgets to get off of it. Let's do this. Let's go to Louisiana, and we'll see if we can start the day off with an approved, maybe.
Now 9:04. The Louisiana Committee on Parole is impaneled at headquarters in Baton Rouge. Serving on the panel today to my left is Mr. Barra. To my right is Mr. Freeman. With the staff here, introduce yourself. There's Carla Williams.
Francis Abbott.
Gail Guerin. Okay. And we're the remote site that we're at currently is Elaine Hunt Correctional Center. With the staff there, please introduce yourself.
Good morning. Warden Keith Turner, Elaine Hunt.
Christy LeBlanc, classification.
Deputy Warden Luke Reams. Joe Buttress, Assistant Warden.
Great, thank you very much. Today we're going to hear the first offender. Sir, if you will, would you please introduce yourself with your name and your GOC number?
Yes, ma'am. Marquise Dalton, 421743.
Okay. Mr. Dalton, according to our records, you're a second-class offender. You're currently serving a 43-year sentence, well, 9 months and 20 days for armed robbery. You were actually on supervision and you were revoked. You had a parole eligibility date last December 4th, 2024. Your adjusted good time date is 4/25/2039, and you have a full term date of 10/12/2048. Does that sound correct?
Yes, ma'am.
If I may, it's attempted armed robbery. I know sometimes it doesn't show up in the record that way.
And you would be Ms. Hutchinson, his attorney, and yes, thank you. It is attempted, and I do see that. Also, with Ms. Hutchinson, we have Mr. Kerry Myers of the Parole Project, who's in support today. We do have a victim who is here present and will speak at the appropriate. At this point, I would like to ask Warden Turner, do you have any information about this offender and anything that we need to know?
Yes, ma'am. He's done some good things for us since he's been here. We received him in 2019. He's remained right free for the last 6 years. He's one of our certified mentors here. He does a great job with that. He's earned a degree from Ashland, and he's also completed his victims impact. So he's a very respectful young man. He's done some great things.
Thank you for that input. I have identified everyone I have a record of. I do see individuals there in the room. Would they like to be identified as, or speak?
Madam Chairman, we'll give them an opportunity to introduce themselves just for the record.
Via Dalton, and I'm his daughter. Kristen Dalton, and I'm his wife. Drusilla Dalton, I'm his mother.
Thank you,
And
Mary.
Madam Chairman, I believe one of them is speaking, the gentlelady in the middle.
Okay, great. Very much. Well, at this time, Ms. Hutchinson, would you like to reserve the last word?
Yes, ma'am.
So we'll start off by asking you, Mr. Dalton, what it is that brought you to prison, and why at this time do you think we should consider release?
I'm in prison for attempted armed robbery, December 3rd, 2004. While coming back from Baton Rouge into Zachary, I saw Mr. Fur. I first recognized his truck, and we was headed in the same direction at the time. And when I saw the truck, it reminded me of someone that the girl I was dating during my previous incarceration had been in a relationship with. We continued on our way, and we got to an intersection. He made a right, and towards that right, that was the way that she lived. When I recognized that, when he made the right, I followed behind him. He made a right into the neighborhood. I followed behind him, and he went down the street. Then I stopped and I called him. She didn't answer the phone. When later on, after riding, I finally caught up with him. One of the guys in the vehicle was like, somebody's throwing his hands up. I turned around and stopped. And I was approached by Mrs. Brown at that time. Mrs. Brown was very respectful, very cordial. She was hospitable. And at that time, I could admit it, like, this was a misidentity. When I seen the individual, it wasn't the guy who I thought he was. But I didn't want the guys who I was with to think I was, know the real reason why I was following them. So I became confrontational. I directed all my attention to Mr. Fur, and I jumped out the vehicle and asked him if he wanted to fight. He told me he didn't want to fight. He asked me why I was following him, and I denied that I was following him. He asked me what I wanted from him. I said I didn't want anything from him. And we went back and forth with that. And I got mad, and I asked him, you ask me that one more time, and he did. I went to the vehicle, and I pulled my gun, and I pointed my gun at him. And I asked him, now ask me that one more time. And he did. And he said, you can have whatever you want. And I said, I want your truck. And he said, the keys are in it. I walked towards his vehicle, and I yelled back at the guys, and I said, y'all gonna help me? And they all just laughed. And at that time, Mrs. Brown started calling for her dad. And I just want to say I had no right to do that and put those young adults and the young man and that woman in that position. But after that I left the scene. I got in my vehicle, and I drove off.
And
I'm sorry. I'm sorry. Since I've been incarcerated for 21 years, I've grown a lot. But I have to apologize for the fear, the impact, the emotional harm that I caused Mr. Brown and Mrs. Fur that night. The impact I had on their families as well as their community. But I see here before you as a different human being, a more mature human being. I come to terms that I didn't like the individual I was. So I had to do a real self-assessment to understand, like, how could I ever put two innocent people in such a position? I had to change my way of thinking. I had to understand, like, how could I be a person that did such a shameful act? So I educated myself. I had to challenge my way of thinking because I was thinking irrationally. And then I had to think, I thought a lot about my daughter. Because at that time, my wife was 4 months pregnant. And I didn't take into consideration, my actions, not only towards them, but towards my victim.
Okay, so, you also had an attempted, second-degree murder charge, is that correct?
Especially after the fact, yes, ma'am.
But that's not what you were discussing, or that is the attempted second-degree murder, yeah.
No, ma'am, I'm sorry, that was attempted armed robbery.
Okay, so what about the attempted second-degree murder?
The accessory after the fact to attempted, accessory after the fact to.
Accessory after the fact.
After the fact, the second-degree murder. I'm sorry. After the crime had happened, it was a guy that shot someone, and I made a lie and I made a 911 call, and I reported my car stolen to try to cover what had happened because I didn't want anything to do with that.
At this time, we'll allow Miss Dalton, your wife, wants to speak, and we'll let her have her say.
Hello, my name is Christy Dalton, and I am Marquise's wife. We've been married for 17 years, and I've known him for 28 years. And we have a 20-year-old daughter who is going into her third year at Southern University, majoring in nursing. And since Marquise has been in prison, he's taken full accountability of his actions that have led him there, and not taking lightly of the victims that were involved in his reason for being incarcerated. And so again, he's grown tremendously in taking accountability, taking classes and courses that have been offered. He's taken counseling, mental health awareness courses, financial literacy. He's taken welding, paralegal studies. He's also been enrolled in their air conditioner and HVAC courses. And he also served as a GED tutor, and also is helping others to learn literacy program, helping others to learn how to read. He has been mentoring to help others gain both their academic and life skills. He's also become a spiritual leader. He is the imam here at the facility. He's a practicing Muslim. He serves as the imam at the facility. He leads prayer, offers guidance, and he helps others again with living within their faith and discipline. And through this institution, their mentor-mentee program, he also helps and supports the others in making better decisions and understanding real world consequences for their actions, and making sure that they understand how not to, they do leave, they don't come back and don't make the same mistakes that he's made.
Right.
He's also maintained a clear.
Okay. Oh, I thought you were finished.
He's maintained a clean disciplinary record since being here at Hunt, and he has basically maintained not just being, not just doing this for show, but actually this is his life and wanting to model and make sure that he's not just, being, he is the person that he genuinely is the person that you see in front of you. He's not, he lives the life of discipline, integrity, and responsibility and ownership of his behavior and the consequences that they cause.
Yeah, we've read a lot of that. I appreciate those comments. I'm going to go ahead and go to Mr. Kerry Myers with the Pearl Project.
Good morning, Kerry Myers with Louisiana Parole Project here to let this board know we have accepted Mr. Dalton as a client. And for the reasons I think you may have already seen, it's not just words that he's spoken to you today. He's held himself to a higher standard. He holds the people around him to a higher standard. He has a family that he also recognizes he has to have that higher standard. His programming, his disciplinary record have all been exceptional. Parole Project, because of his lengthy incarceration, is here to provide him with the transitional services that he needs. We are prepared to work with him for as long as necessary. Matter of fact, we actually plan to work with him in an extended period of time to make sure he is ready to move back into society. When he completes our program, he is highly employable. Our employment team will work with him if needed, but he already has employment opportunities waiting for him. We understand that, you know, the length of time his incarceration will have some particularly relevant things that he needs to learn in our program, and we are prepared to help him. He'll be evaluated by our social workers. He'll go through the programming. He'll understand what it takes technology, financial literacy, social norms, workplace protocols. Those are the things that we'll be able to offer him. But Mr. Dalton has done the hard work. What you see is before you is who he is, and we would just ask this board to consider those things in granting him his parole today.
Yeah, Ms. Hutchinson, would you like to wrap up for Mr. Dalton?
Yes, ma'am. Thank you, committee, for taking your time to hear us today. You've received a comprehensive parole packet from me that introduces you to the Marquis of today, the man that I've come to know and represent. So I don't plan on going through that packet with you right now, but instead, I'd like to maybe address some concerns I think the committee may have and what we've done with that. And so if I could, I'd like to describe Marquis's life in two distinct halves. The first half being the last 20 years and the other half being the 20 years prior to that. The first half, I'm sure you guys have documented in front of you in his record. That version of Marquis had arrests, misdemeanors, felonies, one poor decision after another, none of which we're skirting around. Even the impending birth of his child, of his daughter, like he talked about, didn't really deter him from the longing to fit in or masking his insecurities with this tough guy persona, seeking validation from people who ultimately didn't matter. And Marquis was failing. With the first charge that you brought up earlier, he did enter prison and do about 5 years on that term, but he didn't focus on rehabilitation or education. He merely did the time and was paroled. It's the difference between the first half 20 and the second half 20. So again, he got out and he failed. He caused a great trauma and harm to those two young people in a way that even at the time of the crime, he failed to really even understand the magnitude of his crime. But the Marquis that's before you today, this Marquis of the last 20 years is quite different. And he's driven by two words, purpose and discipline. And I don't want to start with my own words. If you look in exhibits 15 of my packet, you'll see a letter of appreciation from various deputy wardens, program directors, and the warden of Elaine Hunt at the time that recognized Marquis as a a person who has dedicated an extraordinary amount of time to helping others rehabilitate. In that letter, they called his mentorship a living testament to the value and hope that comes from true transformation. And this is the staff that sees Marquise every day. There's a 2024 recognition letter, character letter, again signed by institutional leaders that called Marquise the driving force behind the success of multiple rehabilitative efforts. And in the October 2024 letter from, I believe it was a social worker or counselor here, that talked about Marquise being a well-respected mentor and how he advocated for help introduce and help co-facilitate a program called Getting Ahead in a Just Getting By world, because he saw fit to have that class in the institution and he wanted to see it here. You'll also see in Exhibit 13 a letter from Mr. Grove, a Toastmaster, that talks about the same initiative that Marquise took to get a Toastmasters class chartered here. And Toastmasters for individuals is not just about making oral arguments. It's an instrument that can be used to help people articulate themselves and de-escalate situations with words, something that Marquise couldn't do then. Those of you who are familiar with Marquise's sentencing transcripts can recall a young man that struggled to articulate himself and couldn't even explain to Judge Marabella at the time the root of his anger. Today he's educated and has programming and in leadership, and he's learned how to speak effectively. He can de-escalate conflicts and lead with emotional intelligence. He's been chosen by the institution to take part in public-facing programs like the Frederick Douglass Project. So he's been able to interact with legislators, citizens, church congregations, showing them what transformation looks like. Kerry said it. I think the staff here have said it, like he has truly done the work. You have in front of you a thoughtful and intentional reentry plan. As Kerry stated, Marquise would be with us for as long as you all deem necessary, because he does want to gradually reintegrate with his family and reconnect. I think the board knows from your other hearings, like revocation hearings, that the transition from incarceration to cohabitation after decades apart can be difficult. And so Marquise understood that, and that's why both him and his wife wanted to go through counseling before they got back in the home together, so that there would be a healthy adjustment. And I think that also speaks to his maturity. As Kerry said, Mr. Lacey, whose letter is in Exhibit 13, offered Marquise an apprenticeship with HVAC, and also LPP, and our letter provided 2 second chance employers within his area of expertise that he would be able to work in.
Nice.
If I could, just to close out, I do understand that the board has to also weigh the time served versus the sentencing. I would like the board to know that while Marquise has a 40-year sentence for the attempted robbery and a 10-year sentence for the possession of a firearm as a felon that ran concurrent, it puts him right at about 50% of his time. However, Marquise has served 100% of the time that the state offered him a plea deal. So at the time of trial, the state felt that a 20-year sentence was sufficient for the crime that he committed. Marquise obviously decided to go to trial, and because of the habitual offender statute, he had an increase in his sentencing. But I do want the board to recognize that the state did believe that 20 years was enough for Marquise. And if we take that into consideration, he has completed 100% of that time. He is a mentor in RDAP and has passionately worked with other programming. I put in that packet an actual weekly schedule just to see how much work Marquise does within the prison system. We are prepared to accept with any conditions and guidelines that this board sees fit, and we just ask that you see the difference, the profound demonstrated difference between Marquise of the past and Marquise today. Thank you.
We do all that information in our packet, 260 pages. So at this time, we're going to allow Ms. Jasmine Matthews an opportunity to speak to the panel. state your name and your relationship to the case.
So my name is Jasmine Matthews. I am the daughter of Oscar Whitney, the accessory to the second degree murder. After hearing everything that Mr. Marquis and his attorney spoke about, I don't have any ill intentions towards him. I know he was the accessory to that murder, but at the end of the day, I do believe he has changed. I just want him to know that even though you wasn't the person who actually did it, it still impacted me. And I do have a lot of questions because nobody really knows what happened. And I do understand that he has a daughter. At the end of the day, I'm a daughter who lost her dad at 3 years old. I can't get that back. But I do believe in second chances. I do want him to have that, that bond with his daughter that he missed out on. So I do forgive him for being a part of that. And I think my understanding for that is just because I am a criminal justice major. I am getting my master's in criminal justice, so I know the ins and outs of the system. So I do appreciate him even, acknowledging the fact that he told a lie and he owned up to it and he did the work in prison. So I can't fault him at that, but I do have questions. If he is granted parole today, I do want to speak with him, if that is okay. And I do appreciate him, apologizing for, what he's done and how he tried to make an impact in our community and things like that, so.
Jasmine, you've been very brave and gracious today. Thank you for being here. As far as the communication goes, I'm going to allow our victims group to moderate that decision. Ms. Hutchinson, you always do a very good job preparing. I would say that I really think the change started in 2017 for him. I think that's when he may have turned the curve in my review of his file, when he started getting serious about his programming. And there is a lot to consider. Do my colleagues have any questions?
I do. First off, why did you come to hunt? Why did they send you to hunt?
I came to hunt from the police barracks. I had received a write-up for an unauthorized visit.
Okay. All right, and visit.
Okay.
Okay. And just, I'm kind of like the daughter said, I'm a little confused. You called in and said somebody stole your car. How was that an accessory? How were you trying to cover up or help out whoever had committed the murder?
Because by me calling in that the car was stolen and that I didn't admit what had happened. I didn't tell the truth that it was a lie. The car wasn't stolen. It was my car. And by me not being upfront with them, I contributed to him getting away or trying to him getting away and not being accountable, I guess, for his actions. So I contributed to that. I lied.
Okay, and I do want to acknowledge you have done a lot, and I'm looking at the report that was sent in by your attorney, and you've done a lot of classes since your other hearing, and appreciate you putting in the hard work. And once again, I also want to thank the victim for those brave words.
And Mr. Bonner.
I too have questions about that attempted second degree murder, because I'm reading in the pre-parole investigation and it says that you were actually shooting. What really happened that day?
It goes to the day of the young man's trial. I had already received my sentence, and my cousin had already received our sentence for accessory after the fact. the lawyers came in, we was in the bullpen, they came in the bullpen, and they was like, you need to help him out. They said that I want to make sure I tell you the truth. And they said they asked me to say that I had shot out the T-tops. I said, sir, I didn't do that. I'm not going to say that. It was my cousin's friend. So my cousin said, well, I'll say it if it's okay with him. They was like, it'll help him out. You know, y'all, it's not going to come back and haunt y'all. But I told him I would not say that. I'm not going to admit to something I didn't do. And so my cousin made that statement at trial. I didn't, but I did not shoot out those T-tops, sir. And I just want to say I apologize to that victim. I apologize for that scene ever happened, not being responsible. Not because that was my call, and I should have been brave enough to say, but I was passed out. That was my irresponsible. I wish I could have been more brave to stand up and say something. I was the coward in that situation for not being willing to stand up for what was right. And I apologize. I apologize for that.
You're telling me about what happened at the courthouse. What
Yes,
happened on the street? What did you know? What did you see? It was more than just reporting the car stolen. It says you were in the car.
Yes, sir. Oh, I'm sorry.
Y'all ran across the guy on the airline highway. Y'all followed him around a couple of times during the day. Go from that part. How did it all end up after that?
Oh, I apologize. Thank you, sir, for explaining that. Earlier that day, we went to a gas station. Me and my cousin, we went to the gas station. That's when we found his friend and another guy. They was in another car. He went into the store and bought us something to drink. My cousin went in the store and bought us something to drink. They was acting like, where we going? We're going to a club. They followed behind us, paused right there. They had got into it with him at the store. I stayed in the car. I don't know the transaction that happened between them in the store. We drove to the club, spent some time at the club. Late on that night, the guy that's driving the other car was like, I'm about to go home. I gotta get off of work in the morning. Would you drop him off? He got in the car, we rode around, we drinking. I pass out in the front seat. I'm sleeping in the front seat. Next thing I remember, they wake me up. He wakes me up and he tells me, man, I think I shot somebody. I like, what? We flee the scene. We're behind the mall of Louisiana. I mean, the mall, I forgot the name of the neighborhood. And we come to a place where you can't go forward, a barricade. And we all get out and run. And that's when I go when I get to a resident, I make a phone call and reported the car stolen.
All right, that fills in some gaps. Thank you.
Panel prepared to vote?
Yes.
Okay, Mr. Dalton, my vote today is to grant parole to the Parole Project to follow their guidelines for the length of time that it takes to make you an acceptable risk for reentry in the home. And I don't have any additional conditions than the standard 21. Mr. Freeman.
Okay, it's gonna be the same, but I'm requiring that you stay at the parole project a minimum of 1 year. I want him at that parole project, learning what's going on. Him and his wife can work on their relationship. They hadn't been around each other for a long time. And if he ever wants to meet with the victim, then he can arrange that through our victim coordinator. So that's my vote today. I'm sure the parole project will do drug screens and stuff of that nature. So that's all my condition, that you stay there 1 year.
And Mr. Bowman.
I'm gonna go ahead and, concur with my colleague for the same reason.
Mr. Dalton, your request for parole has been granted with conditions that you go to the parole project and have elevated drug screens. So that concludes our hearing for Mr. Dalton.
Approved?
It is so rare that we start out with an approval. I'm not sure what to think of that. So let's look at the birds for a second while we gather our thoughts and figure out where we're going to go next. I'm shocked, I tell you. We started the day with an approval. Let's go back to Judge Stevens.
Convicted of all that.
And 21-37530, the state of Texas versus William Permitter, that's familiar. There's a.
Yeah.
This computer pad was acting odd again.
No, I should send something to you. They're probably trying to do too many things at once.
There's a motion to dismiss the case filed by the state in William Matthew Permitter in 37530. The court has signed that, and that case is hereby dismissed. Now we go to Mariah Gallo. That's you?
Yes, sir.
It's slow.
It's like me.
And you were here with Mr. Smith, is your attorney,
Yeah.
right? Okay. Does the defendant waive a formal reading of the indictment and the arraignment in 24 CR 1607? Can we proceed in summary?
Yes, Judge, we waive the reading.
In summary, this indictment alleges that on or about June 23rd, 2024 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Do you understand what you were charged with here?
Yes.
Judge, this is a plea on the lesser.
Agreement that's been reached. It looks like you would be pleading guilty to the lesser included Class A misdemeanor assault, which carries with it up to 1 year in the county jail and or a fine up to $4,000. Is that your understanding of the plan, and do you understand the punishment range you are facing?
Yes.
An agreement has been reached where you would. Is that deferred?
Yes, sir.
Okay. It looks like it was marked there.
That tablet is like, the delay on that was just absurd this morning. I don't know what the deal is.
It's a poor mechanic who blames his tools.
No, then let's rewind to Monday, because I think I heard some others complaining.
Blake was complaining more than you were about that too.
It's possible. I don't know. I'm not going to say that on the record.
All right. The agreement has been reached here in all seriousness, because this is, of course, serious. Everything up here is serious. You would be pleading guilty, placed on deferred or unadjudicated probation for 2 years for this Class A misdemeanor assault. Ad gave y'all a lot of trouble.
Yes, sir.
Figured out.
Is that your understanding of the plan? There is no fine here,
Yes, sir.
but there will be terms and conditions of probation which are normal and customary for this type of offense. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this lesser included Class A misdemeanor of assault in this case? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence and without objection.
No objection.
Admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses, such as the one that you have pleaded guilty to today. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true states, so help you God.
Yes.
States Exhibit 1 made a part of the record for all purposes. Is a pre-sentence report waived?
Yes.
We're going to move forward today.
Yes, Judge.
Quicker she starts, quicker it ends.
That's correct, Judge.
If nothing further, I'm going to find that you, Ms. Gallo, are pleading guilty today voluntarily to this lesser included Class A misdemeanor of assault. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do it. I'm going to place you instead on deferred or unadjudicated probation. I'm deferring all finding of guilt so long as you follow the terms and conditions of probation that this nice lady with the probation office is going to go over with you. You'll be placed on probation for 2 years. There will be terms and conditions normal and customary for this type of offense. You're going to complete an anger management program. That's always good. I think everybody ought to take that. It helps them understand that when they lose their composure, they have consequences and they kind of think about it and control themselves better. Complete a moral reclamation therapy, and that's good choice making in general. Those are all good things. Helps you be a better person. Make sure you follow these. And then your probation will be dismissed at the end favorably, and you just move on with your life without a conviction. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in county jail. And we don't want that, right? Okay. Please see the probation officer. Okay, thank you very much.
Just briefly before we end, is she eligible for early termination of the deferred?
If she's not, she'd be the first one in 18 and a half years who wasn't eligible. Yeah, but you can be reviewed in a third. And it's up to the probation office. Generally, though, there's a minimum time. It's generally a year. Then we have a good track record because you're lucky. You were indicted for something that carries with it up to 20 years in prison. You got to do your part and make better choices, and then you don't have to worry about this. Let me ask you one other thing. Are you still at 10718? Okay.
Okie dokie. Let's go back up to Michigan and spend a little more time with Judge Simpson.
Ms. Skardutis, can you please state your name for the record?
Sure. My name's Amanda Lynn Skardutis.
Thank you.
Your Honor, we have come to a plea agreement. Unfortunately, we came to that agreement after the plea form was due, so we're asking for a very brief adjournment so that we can have that ready for the next court date.
2 weeks out. That was July 31st, 2025, 9 a.m. Bond continued.
Thank you. Ms. Skardutis, I'll talk to you, okay?
Okay, thank you so much. Y'all have a very wonderful day.
Thank you.
You do the same. Thank you.
Thank you.
Here he'd shoot it.
I'm not.
You're not gonna. Darn. All right. Court does call the case, People versus Andrew Patton.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Christina Costantino, appearing on behalf of Mr. Patton. Mr. Patton, can you please state your name for the court?
Andrew Spencer Patton.
Thank you. What are we doing on these?
Your Honor, with regards to the case number ending in 5110, it's my understanding that discovery is complete to my knowledge, and we would be asking to have that matter set for a preliminary exam. But with regards to his other matter ending in 5154, I have just been appointed late last evening to that matter, so I would be asking that the PCC be adjourned so I can obtain discovery.
In the case ending in 5154, probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond on that matter will continue. On the other matter, would the people have their witnesses available? Would the parties be available? Will the 29th work, or Did you need another day?
The 29th will work, Judge.
Will? Okay, fantastic. All right. Preliminary examination in this matter will be set in person, July 29th, 2025, 9 a.m. That's before Judge Washington.
Thank you very much, Judge.
Thank you. Bond will continue.
Thank you, Your Honor.
Thank you. Calls the case, People versus James Williams.
Christina Costantino appearing on behalf of Mr. Williams. Mr. Williams, can you unmute and state your name for the court?
Yes, ma'am. James Williams.
Your Honor, this is a date and time set for PCC. We have been working on mitigation, but our mitigation specialist does need some additional time to complete a mitigation report, given that we would be asking for an adjournment of the PCC.
Without objection, August 7th, 2025, 9 a.m. Bond continue.
Thank you very much, Judge. Have a good rest of your day.
Thank you.
So we'll come back to Judge Simpson's adjournment court at some point, but let's go down to Miami and Judge Grumpy Pants because it's getting close to lunchtime, so we should probably check in and see how she's doing.
Next case is page 8. White Jack. Hi, Mr. Jack. You were arrested for attempted tampering with physical evidence and resisting an officer without violence. I will appoint the public defender's office for you. You're out on probation. Hold for F20 15901. Probable cause for the charges there. I'm sorry. There's a hold for F20 15901 for his probation. Count 1 attempt. It's not attempted. It's tampering with evidence. It's a $2,500 bond. Count 2 resisting without is $500. You'll see your judge tomorrow. Next is Dennis Villa Hui, page 9. Does he need a Spanish interpreter? Good afternoon, sir. Do you speak English?
Spanish, please.
Sir, you were arrested for possession, 2 counts of possession with intent to sell crystal meth. I will appoint the public defender's office for you.
2 cargos por posesión con intención de vender metanfetamina cristal. Le asigno al abogado de la defensa pública que está a su mano izquierda para esta audiencia.
There's probable cause for the charges of setting a bond, $7,500 count 1 and $7,500 bond count 2.
Hay motivo fundado para los cargos, 7,500 cargo 1, 7,500 cargo 2.
Have a nice day.
Que tenga buen día.
Second. Hi, Mr. Corey. What brings you here?
Here. Manuel Garcia, Judge.
You're doing criminal cases now? I thought you told me.
Well, we represent him already, and yeah.
I don't know. We got to find the page. Give us a minute.
Okay, Judge. Thank you.
You got a big calendar. Manuel Garcia, you said?
Yes, ma'am.
Okay, we'll look for him.
Thank you, Judge.
Antone Ross Smith, page 10.
What was the first name on that client? Judge? The last name was Garcia and the first one.
He's on page, he's number 58 on the calendar.
58.
On page 20.
Page 20, 58. We'll get it next. Page 20.
Yeah, we have to pick up the inmate, Your Honor. He's not here yet.
Mr. Corey, they have to go pick him up. You want to go somewhere else and come back?
What time would you like me back?
I don't know. It may take him 15 minutes. I don't know.
Okay, yeah, no problem, Judge.
20?
I'll be around.
Thanks.
Thank you, Judge.
All right. So hi, Mr. Ross Smith. You were arrested for 2 cases, possession of cocaine residue, possession of drug paraphernalia, as well as petty theft, 2 or more convictions. I will appoint the public defender's office for you. There's probable cause for petty theft, 2 or more convictions. You are ordered to stay away from the Walmart store at 3200 Northwest 79th Street in Miami, Florida. You are not allowed to go to that location. You must stay away from there. Do you understand, sir? All right. And then the other case, the possession of cocaine. It's residue, pipe with residue. There's probable cause as well. State, do you have an objection to a program like TAP?
Yes. The defendant's got a conviction for petty theft, 2 or more convictions from earlier this year. I see a prior 16-month prison sentence and then 129 days in jail last year.
All right, I'm setting a bond.
Anything from,
Yes,
Ms. Beth, you're saying from this year?
it
Well,
is there.
it was January, but the incident occurred, I guess.
From September. It's a September 2024 incident.
I'm setting a bond on
You
F-20.
consider TAP, Judge?
I did. I'm not giving it to him, the conviction from technically this year. F-25-15073 is $1,000 bond count 1 and $500 count 2. The other case, petty theft, 2 or more convictions, that's $2,500. Good day, sir. Next is Santino Munoz. We're on page 10. Good afternoon, sir. Good morning, sir. You were arrested for possession of cocaine, petty theft, resisting an officer without violence, possession of drug paraphernalia. Is English okay?
Yes.
I will appoint the public defender's office for you, so I'm just reviewing for probable cause. There's probable cause for all the charges. You are ordered to stay away from the Walmart store at 1425 Northeast 163rd Street in Miami, Florida. You are not allowed to go to that store and you must stay away from there, sir. Do you understand the stay away order?
Yes, ma'am.
Looking at his priors, I
There
guess
was
the resisting as well is concerning.
Right, he did 120 days last year requesting a bond.
He has a conviction from July 8th. That's like 9 days ago
Yeah,
for drug paraphernalia
and petty theft.
and petty theft. I'm setting a bond. Possession of cocaine is $1,000. Count 2, petty theft is $500. Count 3, resisting an officer without violence is $500. And count 4, possession of drug paraphernalia is $500. Stay out of that Walmart. Have a good day. All right, you got it. I said 1,000, 5, 5, and 5. Next case is Jason Scarcella. Good morning, sir. You were arrested for battery, 2 counts of battery on a law enforcement officer and battery on a person 65 or older. Sir, can you afford to hire an attorney?
No.
I will appoint the public defender's office for you.
I think it may be the same officer in counts 1 and 2.
probable cause for battery on a person age 65 or older. And also one count, a battery on a law enforcement officer. You are ordered to stay away from Juan Rivero, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the victim, his home and school and place of employment at all times. And you can return to the victim's residence one time only with a police officer to retrieve your personal belongings. If you go without the police or if you stay there, you will be arrested. Do you understand, sir?
I did, yes, ma'am.
You didn't hear it?
No, I said I understand.
Okay, do you have somewhere else you can stay?
I probably could. I have money in my account. If I could get out, my fiduciary would get me a room, until we figure out what we're gonna do. Because I was living there for like 2 months, but I have a lot of money in my VA account.
What are you living in, an ALF?
I was living at that house with Juan Rivera.
Is it an ALF? Is this a living facility or like a rooming house?
I think it's an ALF. Yes, ma'am.
Ms. Cora, do you want to inquire regarding hospital or no?
VA, he may have VA benefits, I don't know.
What'd you say?
I think he said VA, I don't know if he's former military.
He prefers to go independently, Judge.
Okay.
He has pending appointments.
So count one, there's probable cause for battery on a person 65 or older. It's $5,000. Count two, the battery on a law enforcement officer.
Just count one is Batleo, right?
I'm sorry, count one, battery on a law enforcement officer. What do you want, 5,000 on that?
Yes.
He has no priors. Do you mind if I look?
But I think, did he bite the officer? Hold on.
That's what I was looking at.
Right, he bit Officer Thompson.
Oh, no, count one is $5,000 bond. Count two, you want ROR? And count three, the battery on the elderly, there's probable cause for that too. The victim's partially paralyzed on the left side of his body as well.
And also the age.
I know he's over C68. What do you want for count two? You want 3,000, okay?
Requesting 5,000.
There's no, you see priors anywhere for him?
I don't know how long he's been in Miami. He's from New York.
Since 2020.
Nothing really to mention.
All right. I'll set count two at $3,500. Have a good day, sir.
Count three, Your Honor?
I'm sorry, count three is 3,500. One is 5,000, two is ROR, three is 3,500. Have a good day, sir. Next is Leonardo Dominguez, page 10.
Judge, can Mr. Scarcella go back to the home one time with the police to get his belongings?
I already told him he could.
Oh, I'm sorry, I missed it. Thank you.
Okay, I miss a lot too. He can go back with one time only with a police officer within 48 hours of release from jail. Okay, next is Mr. Dominguez.
Spanish, please.
Good morning, sir. You were arrested for battery on a person age 65 or older. I will appoint the public defender's office for you.
Usted fue arrestado por agresión corporal hacia una persona de 65 años o más y le asigna al abogado de la defensa pública para que lo represente.
There's probable cause for battery on a person's, actually, it doesn't give the victim's age. It just says,
Right, it's a little unclear.
so he's a taxi driver and has a fight with another taxi driver because the other guy threw a banana peel on the ground and they got upset.
Ok. Usted tuvo una bronca con otro chofer de taxi porque tiró una cáscara de plátano y usted se disgustó.
And then he grabbed a bag that had rocks in it and hit the victim, or tried to
Y
hit the.
después usted agarró una bolsa llena de piedra y se la tiró a la víctima.
Yeah, he hit the victim with a bag that had a rock in it.
Tenía una piedra esa bolsa.
There may
Sí,
be,
y le
the state may charge it as an aggravated battery, but that's up to the state. Sir, you are ordered to stay away from the alleged victim whose initials are RW.
Se le ordena que se mantenga alejado de la presunta víctima RW.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto con la víctima ni directa ni indirectamente, ni en persona, ni por teléfono, ni por escrito, ni por medio de terceras personas.
And you must stay at least 500 feet away from the victim, his home, school, and place of employment at all times.
Tiene que mantenerse alejado de la víctima por lo menos 500 pies de su casa, escuela y lugar de empleo en todo momento.
And if you see the victim at the airport when you're, or while driving your taxi, you have to stay away from him. Do you understand?
Si usted ve a la víctima en el aeropuerto manejando el taxi, tiene que mantenerse alejado de la víctima. ¿Usted comprende?
Okay.
Yes.
All right. What bond do you want, state? He's 69.
On a 3,500.
$3,000 bonds. Have a nice day.
Una fianza le fijo de $3,000, señor.
So yeah, we're fast approaching lunch and she's doing all right. Good for her. Didn't hear her scream once. Things are weird. Let's go back to Louisiana. Try that again.
Rouge, serving on the panel to my left is Mr. Barra. To my right is Mr. Freeman. I'm Miss Ledoux. Would the offender in front of us state your name and your DSB number for the record?
Harold Cowan, 570-736.
Okay. Mr. Cowan, do you go by Jason or Harold?
Jason, most things.
Mr. Cowan, I'm going to read some information into the file, and after that, we're going to allow the individuals who have joined us via Zoom make statements on your behalf, and then we're going to be asking you some questions. So, Mr. Cowan, first. Find that you are a first felony offender currently serving a 15-year sentence for the charge of indecent behavior with a juvenile. Apparently you had a revocation as well. You have a parole eligibility date that passed 8/7/2016. You're not eligible for a good time date, and you have a full term date 8/9/2026. Does that sound correct?
Yes, ma'am.
So, Jason, if you would at this time, would you please inform this panel why you're currently incarcerated, what brought you to jail, and why this panel should consider early release at this time?
I was charged with 3 counts of indecent behavior with a juvenile. In, I believe it was 97 or 98, I was watching a friend's son while she was working that night. And after we went to bed, he came and slept in the same room with me and the same bed with me. And sometime during the night, I touched him inappropriately. With Landon and Josh, they, I had been drinking heavily and they came over. They were friends of friends, and I believe they were 16 at the time. And during each instance, we were in the same bed and I touched them inappropriately. Each time they asked me to stop, I did stop. I have no excuse for what I did. Alcohol was a factor in the cases, but it's not the. I made the decision. I did that. I committed the crime. During my incarceration, I've changed. I'm not the same person I was when I was initially locked up, arrested, and committed those crimes. God, to come into prison for God to change me and work in my life. Since I've been incarcerated, I've been sober for 14 years. I'm maintaining my recovery and sobriety. I have taken numerous classes to improve myself. I learned to manage and learn new life skills and coping, to increase my vocational trades. I have taken numerous Bible studies. I've taken alcohol and drug. I've taken Conquering Chemical Dependency, 12-step program. I've attended AA meetings. Completed the Fox 7 Transition Residential Drug and Alcohol Program. I did anger management, Cage Your Rage. I'm currently in the Fox 7 Fox 6 Veterans Mentorship Program. We do classes in there. I recently completed the addiction recovery relapse prevention class. I've taken personal development, just finished victims impact, taken Cage Your Rage, pre-release, living in freedom, living in balance. I've taken the release pre-entry prep course. I am an NCCR instructor now. I completed the instructor certification training program. I've gotten completed level 1 of heating and cooling. I'm currently enrolled in HVAC level 2. I've completed core field safety and safety technology and have been teaching field safety.
Okay. Listen, your program's warden, I'd like to address you and ask you, has this offender taken the sex offender treatment?
No, ma'am. And I was gonna bring that up.
Go ahead and tell us about this offender in your opinion.
So he's been here, I think we received him back in 2023. He has, remained right up free since he's been here. He has done some programming. He has a 2026 full term date. And there are some of the more important classes that I think he needs that he has not completed. And, in my opinion, until, he gets those necessary classes that he needs, I think, he kind of, needs to focus on those things instead of some of the things that he's been focusing on.
Has he applied to take sex offender?
No, ma'am.
That's what I need to know.
I am currently enrolled in the risk management class. Phase 1. Upon
so what I have here was what we have printed out, and she said she just had this checked here within the last couple of days. He still needs sex offender treatment.
We have several people today that would like to speak on your behalf, and they are all on Zoom. And I'll go ahead and start with your father, Howard Cohen. Sir, if you'll just make sure you're unmuted and make your remarks to the panel.
Yes, I'm here.
Okay, great.
Okay. I'm Harold Calvin. I'm his father. And he has changed. He's not the same person he was when he was locked up. He has gotten deep in the Word. He's a Christian now. He got deep in the Word. during the times of incarceration, he has reached out to others and helped others as far as acquiring Bibles and getting signed up for Bible studies and different things like that. As far as he himself, his demeanor has changed. He's a calmer person. He's more thoughtful. And when we go discussing family matters or issues in the family, things like that, when we come to visit, he's more thoughtful about his consideration. He's not one that's jumping to a conclusion, and just saying, well, he should have done this or should have done that. And we'll discuss things in the family. He has taken a lot of study there and correspondence on Bible studies and things like that. I know he's taken self-help courses. Also, as he says, he's been pursuing furthering his education and safety. He worked as a safety supervisor offshore on rig safety. He has water safety training such as that. And he has been, taking his studies in HVAC and all that in preparation for jobs when he gets out. Now, as far as his release, should he be paroled, he would be coming and staying with his brother and I here. I have a vehicle already. I have 2 trucks. I'll give him 1 truck. He'll have transportation to go out and seek employment, to go back and forth to work. I do have money set aside to support him till he can kind of get on his feet, get established in a job, and to help support him as far as, his needs that he might incur, as far as expenses. Our pastor at church has worked and counseled other parolees in the church. In fact, we have had 2 sex offenders that have been attending church there with permission of the pastor of the church, and they have since moved on to other areas. But he has counseled with parolees before, both here in at our local church and when he was pastoring in Little Rock, Arkansas. So he does have a support group there in the church. Pastor has counseled with him before. He knows what, would be involved in participating in church and being a part of the church there. So we do have a home support set up. I do have contacts in the community, different ones, as far as maybe possibly going to work in HVAC or something of that nature when he gets out.
Thank you very much for your comments. We also have 2 others who would like to speak. Susan Hutchins, the aunt.
Yes, ma'am, I'm here.
Director.
Good morning. I'm Susan Hutchins. I'm his aunt, and I want to thank you for the opportunity to allow us to speak on his behalf. As to what I've seen in Jason, all the times I've visited him, he's always talking about all the classes he's been taking and helping others and how he stays so busy, which they've talked about some already. He's helped teach GED classes to other inmates, trying to help them better themselves. But he's also taken lots of classes and working toward degrees to help better himself, to find work, to be self-supported when he does get out. I've seen him grow spiritually. I believe he almost has a degree in theology. He's even preached for some of their services. I never thought I would see that, so I'm thankful for the positive change in him. I will be available also to support him as well as his family as he integrates back into society. He will have a stable residence and family support and financial assistance while getting back on his feet. I can help him with that also. I believe he's ready to transition back into the community. I want to thank you for your time, your consideration in reviewing his case, and I'm hopeful for his early release. Thank you.
Thank you, Ms. Hutchins. Appreciate your comment. We also have Miss Wiley, Alicia Wiley's sister, and thank you for joining us. If you'll just direct your comments to us.
Good morning. My name is Alicia Wiley, and I'm his sister. Jason and I have grown very close over the years that he's been incarcerated. We were not very close prior to his incarceration for obvious reasons. We lived 2 different lifestyles. I've watched him grow spiritually, mentally. He's been humbled by his experience while he's been incarcerated. As I've said, he has surrendered his life to God. I have seen that, the fruits of that relationship that he's developed.
All right, great. Thank you so much. Appreciate your support of him. This case, I'm gonna defer to Mr. Barra to lead the discussion, questioning.
All right, just a couple of brief points about the case. We have Mr. Cohen before us, a male classified as a, some say second, some say first, depending on that how we interpret that Mississippi conviction. On March 2nd of 2011, in the parish of Concordia, Mr. Cohen pled guilty to amended charge of indecent behavior with a juvenile, 3 counts. Sentenced to serve 5 years hard labor, each count to run consecutive. Jail term was suspended and he was placed on 5-year supervised probation. Then, while on probation, Mr. Cohen was arrested on October 27, 2011 by the Adams County Sheriff's Office in Mississippi for the offense of child fondling, touching a child for lustful purposes. And on May 23, 2012, in Adams County, Mr. Cohen pled guilty to child fondling and touching for lustful purposes. He was sentenced to serve 12 years in the Mississippi Department of Corrections to run consecutive with any sentence ordered to be served in the state of Louisiana. And the Louisiana probation was revoked on May 30th, 2012. All public officials contacted or opposed. All the law enforcement is opposed. The victim, we have opposition from the victim also. You have a high risk level on your static 99. And I really don't have any questions. Mr. Ledoux covered the questions, but that's just the facts of the case. Anybody else has questions?
How many years have you served? Actual time?
14 years.
14 years. Okay. I have nothing else.
And do note that you have a good time date in August of next year, needing to complete those
8, 9, 26 is a good time.
classes.
Okay. I have no other questions.
Should the panel have no further questions, Mr. Barra, you prepared to vote?
Yes. Well, Mr. Cohen, today I'm going to have to vote to deny request, ask you to complete those sex offender classes that you still need to do to better yourself. I mean, it's all about getting you right before you get out. And those classes are one of the main things that we do require. And it does take a while to get through all 4 phases of it. So with you having such an early good time date coming up next year and the amount of classes you need to do to get yourself right, there really isn't any time to release you. You need to just do the classes. So today I vote to deny your parole and I ask you to complete the class.
Yes, Mr. Freeman.
My vote is to grant conditional on completing the sex offender treatment. And the only reason I'm granting is because I want you on supervision. And like Mr. Barra said, you get out next year. So I want you on some supervision to make sure you're in an approved residence, you're going to your classes on the outside, you do all your registration and notification, and make sure that you check all the X's and O's to keep the community safe. But as I say, I'm gonna grant with completion of that sex offender class, and I'm gonna order, I want you on electronic monitoring for the remainder of your sentence upon release. That's my vote.
Mr. Cohen, you need a unanimous vote. My vote is also to deny parole at this time. Static 99 of 3 is a very high score, which is indicative of public safety risk. And so while I understand Mr. Freeman's concerns and I appreciate his vote, my vote is also to deny. So you've been denied tonight.
Denied.
I'm sure you all would agree with me. I think that's the right move. As a man of God, if he has actually legitimately found faith, good for him, and I hope it helps him. But there is also God's law and there's man's law. There's the concept of rendering unto Caesar that which is Caesar's, and he needs to continue with his punishment, in my humble opinion. But I don't think any of you would disagree with me on that either. So let's go to Texas. Say good morning to Judge Boyd.
For travel. All right.
Oh, sorry.
She entered a plea and this was for evaluation, is that correct?
Judge, this is actually a compliance hearing for an outcome for felony drug court.
I don't know, I just have a blank sheet of paper. Let me see.
Here you go.
Thank you.
That's the outcome. Sorry, Judge.
Sure, no problem. All right. So she has already entered a plea. And she was rejected from felony drug court. All right, so they're saying that you don't have stable housing. What's going on with you?
So I stay right now where I can stay. I recently just got a phone because I had to get a brand new phone. My ex has all my belongings. And I personally don't want to, like, he lives on the property where I'm not supposed to be. And so I don't want to have contact with him or go to the property or send anybody there to get my belongings. So I've been trying to figure that out. I did speak to my probation officer and he said that he would try to work with me to see how I can
Just
get
one
my
moment.
belongings.
Could I get the steps on this case? It's Vanessa Lynn Mervet. See, we have Odyssey now, so everything is supposed to be electronic, but they don't have the manpower to put everything in the system, so. So none of your information is in the system. So is there a reason, because I see here that they were trying to contact you through your parents?
Yes, so as soon as I got a phone, I was made aware of that through my mom and stuff that
I'm talking to Mike because probation cannot hear you.
so I was made aware that that they wanted me to show up and stuff. So I was trying to figure that out too, and I had talked to my probation officer, but I told me that he wanted me to focus on showing the court first.
So who are you living with? Where are you staying?
So right now I have been like just pretty much staying in hotels and things like that. But because I don't have access to like my ID or social security card.
So how are you affording hotels?
So it's getting paid through my dad right now because I do have job offers, things like that, but the thing is I don't have access to my ID or social security card.
So why are you not staying with your dad?
Because he lives in Wisconsin right now.
All right, so why are you not staying with your mom?
They all my family stays in Wisconsin. The closest family members that I do
Oh,
have is in Boston. But I don't want to like do anything else.
All right, just a second. So here's the thing about Odyssey. If Odyssey is not going to have the stipulations on file and paperwork is missing, I don't even know why we have Odyssey. Like I have nothing to go on with regards to this case. I know there's no contact orders in place with you.
I'll print out the judgment.
No, I just need the stipulations. I don't need it.
Stipulations and into this. Looking at me.
Does anybody have a police report?
Judge, I'll do it right now.
All right, thank you. If you could just email it to me.
Okay.
And counsel, what's being emailed to me is what would have been in the, what was in the stipulations.
Judge, I
Yes.
just do another update while we're waiting
Yes.
on that. Miss Mirabente was supposed to have her TAP evaluation conducted while she was in custody. And if she was not accepted into felony drug court to follow the recommendations of the TAP, she was released without having a TAP, so we did not get to the TAP.
All right, let's do this. If you're drug tested today and you're gonna get drug tested today, what are the results going to be?
Have nothing.
All right. So let's get our drug tested today.
Okay, and I just wanted the court to be aware that we did complete the mental health evaluation and she was all clear there.
All right, so you're gonna do a drug test today. And then we're gonna come back and counsel, then at that time, the court will make a ruling on this and what should be done. And then hopefully by then, we will have something on your case. Okay? So if you'll talk to Miss Abrams is gonna tell you where you need to go for your drug test, okay? And then after you've completed your drug test, you're gonna come back here and that drug test, you're not gonna be charged for it, okay? All right, thank you.
When do you want us to come back, Judge?
As soon as she finishes her drug test, it's the location where she's getting the drug test, it's near the Bear County Jail. And then she'll come back and we will have the results
Today or tomorrow?
today.
See you tomorrow.
Jose Martinez Cardenas, are you here? All right, they're not. This is coming back for the afternoon.
Yes,
And could I have the file on Cheeseman, please? Mhm. Yes, but where is he?
No, I'm just saying,
Yes, thank you. Kylie Brooks. Who's the attorney? Okay. Thank you.
Judge, you have the supplemental report as well as, of course, some of them right there.
Everyone, whisper. Yes.
We're coming before the court to ask for permission for Mr. Brooks to have permission to go to Spokane, Washington to live. Currently he is unhoused and he only has his father here who doesn't really necessarily want him to live with him. In Washington, he has stable living plans to live with his mother. He has a job waiting for him. He has already been accepted, from my understanding, to Spokane, Washington, through the IHOP system. The state has no objection to him going.
Okay. All right. So this is what will end up happening. You'll be transferred to Spokane, Washington, but that officer will give the court updates. And if you violate your conditions of probation there, what will end up happening, they'll ask for you to come back here because a motion will be filed. They'll let us know. And you'll have to come back here to answer for those charges. Do you understand? All right. You're welcome. Do you have any questions?
No, just thank you.
Oh, you're welcome.
Thank you for your.
Oh, you're welcome. I do my best. I try. But you don't. All right. Good luck to you. If you ever need anything, please let us know. Okay. All right. Thank you.
Let's try something new, friends. I just found a new court. This is in the Commonwealth of Kentucky. It is the 40th Judicial Circuit, Monroe County specifically. This is Judge David Williams. I have no idea what this will be like, but let's find out together.
Your Honor,
Go ahead.
the one other issue that we would like to address is Mr. Stockton's motion did request for an inpatient. We have reached out to the director of KCPC to see if
But I hope you have more influence with him than Mr. Stockton or I've ever had with him.
Your Honor, I will be honest, we haven't received a
You go ahead and finish. I interrupt you and then Mr. Stockton get to respond to that.
Your Honor, we had reached out to see if it could be done in outpatient versus inpatient. One for expediency and two, so nobody has to be moved and things like that. We have not yet received a response to that. If that is something that could be accomplished, that it be done outpatient,
Well,
that is what we would
where
request.
He's presently at the Adair County Regional Jail. Do they have a facility there that the person could?
I may speak,
Yes.
we've got better access to KCPC, I guess, because we deal with them on a daily basis, it seems like. But we've already inquired with them, and if it's in the court order, they will evaluate him in person. This is not some possession case. They've got an expert witness that's been able to interview him and examine him, and I think the Commonwealth should have the same right to have him examined in person.
Yeah, I don't really think it's fair to your client.
Oh, Your Honor, I apologize. They can come in person at the facility where he's
They're
at.
not gonna do that. They're gonna transport him to the facility up there. They're not gonna bring the psychiatrist
They
down.
they would Zoom him if they did it.
Yeah.
They can't, they have been doing some of them in person at the jail
Well, I mean,
facility.
it's hard enough to get them to do it in person. I can't think that it would expedite things to order them to come to Adair County.
Yeah.
That's considered outpatient.
Yeah.
What they're talking about is considered outpatient.
Yeah.
Yes.
So, no, we'll just, now, right now we have the trial scheduled for when?
October 27th, I believe.
Do you think it's realistic?
No, they told us if they did a Zoom, it would probably be 6 months, and if they did an in-person, 7 to 9 months. So I don't see any difference between 6 months and 7 to 9 months, I say. I want to, and that way we'll have an evaluation and it'll be thorough and we can move on to trial, hopefully.
Well, that would get us into trial in January or February. I really don't see putting this gentleman on trial around Thanksgiving or Christmas. I mean, it's been my experience that counsel, that jurors do not concentrate very well on cases when they're worried about Christmas vacation or something like that. Now, we were anticipation, we were kind of looking at January and February schedule where
I mean, if you're saying, if we sent the order right now, and even
Thinking
at a
maybe
minimum
March.
7 months, yeah,
So I'm thinking
And then
sometime early
plus-
summer,
the report and then the hearing.
well, yeah,
late spring, early summer.
well, yeah, let's go ahead and send the order and see if we can get them to expedite the thing. You know, I guess they've got a lot of other things going on and everything, but
We'll talk to them and ask them if they can expedite.
you know, I don't think y'all would consider it ex parte communication if I talk directly to them. I think I'm entitled to talk directly to them.
Your Honor, if you could, we have no problem
Up
with
to this
that.
point, I've not been able to exercise any influence on them about anything at this juncture, you know. But I might see what the deal is. You know, this gentleman has a right to a trial. And I want to get him a trial and that as soon as possible. At the same time, it's a complicated case and I want to be fair to the Commonwealth also.
And this is my issue. Once the report is complete, and we don't know when the report's gonna be complete. We started working on these subpoenas. This was October trial date. We started working on this in June. because we're gonna have to domesticate some of these out of state.
Yeah.
So I'll need at least probably 90 days to even get my subpoena served on this case.
Yeah. Okay. Okay, well, there's where we are. If you create an order.
And that
And
motion's not for the 31st in July.
what is it?
The trial. Motion to
The
continue the trial as well as a motion to reschedule the evidentiary hearing.
is all on the 31st,
It's all
Your
on the
Honor.
31st day.
And just to,
What kind of evidentiary hearing we're gonna have?
Regarding the jail staff.
Oh, yeah, that,
Yes.
well, we'll go ahead and have that. I don't, we'll go ahead and schedule that. We'll have that hearing, and then if anything comes up between now and then, we'll know it as far as the schedule or redo it, reschedule the trial.
Just wanna verify on the order, it'd be the criminal responsibility, any issue raised in the report, and there's one other thing.
Mitigation.
Mitigation, okay.
and you're,
Any issue that's raised in the report or any other issue concerning a criminal responsibility or mitigation.
and Your Honor, it was your order that once the order is proposed, that it can be looked at by defense counsel and if
Go
there's
ahead
any.
and send it to you.
Yes, okay.
And if there's something you can agree on to change, we'll do that. If not,
We're the passive form of agreeing on anything.
well, hope springs eternal.
Well,
Just give me an opportunity to give it to them.
I will give it to them.
Give it to them, and you don't have to talk to them about it. You know, if they can send you something in writing. And I would hope that we would reestablish a little better communication between the defense and the prosecution at some juncture. I understand that this team comes in, but I'm not going to be very tolerant of people that just come in to try to, as they say in Monroe County, gom things up. If you have legitimate motions, that sort of thing, I'm more than willing to hear them. But this system does not work unless there is professional courtesies extended by both sides. Okay, both sides. And so let's try to reestablish some of that again. So you can talk to your colleagues about that.
Understand, Your Honor.
I'm talking to both sides about it. Okay. Thank you very much. Jacob Bowles.
I'll get that back over.
Jacob Bowles.
Criminal responsibility mitigation and
Commonwealth versus Jacob Bowles, 22 CR 002. Are you Jacob Bowles? Mr. Bowles, come around. Are you Jacob Bowles?
Yes, Your Honor.
Were you born in 2002?
Yes.
The last 4 digits of your social security number 1163?
Yes, sir.
You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yeah.
Is it substantially correct?
Yes, Your Honor.
Counselor, is there any reason this gentleman should not be sentenced today?
Your Honor, no, but I would like to make a motion for probation.
Okay, please proceed.
Your Honor, I would ask the court to probate Mr. Bowles. I believe that he is a good candidate for probation. This is a pretrial diversion revocation, so this came out of pretrial diversion revocation, so this would be his first felony conviction. He has minimal criminal history. He would be living in Glasgow, so he would be able to be monitored by the local probation office. It is my understanding that he previously has work history within factories around the area, so he'd be able to be employed.
Where did you work, young man?
Agabona.
Yeah.
And he does have contact information that he has made sure is correct for probation to be able to monitor him.
It was a Commonwealth, I have to say.
Well, Your Honor, he was placed on probation in June of 2022, or I'm sorry, May of 2022.
Pretrial diversion?
Pretrial diversion. And he basically absconded in June of 2022, and he's been absconded for 3 years.
No, objection, he was not. He was not. Absconding was not one of the allegations there. He was compliant up until the violation of the new misdemeanor.
May have him confused with somebody else. He was convicted of domestic violence assault fourth on May 29th, 2025 in Barron County. So I don't mind looking at it in shock, but I don't think it should be probated.
Well, I'm going to, the pretrial diversion has been set aside. I'm going to go ahead and impose the sentence, but I will encourage you to file a motion for shock probation as soon as he's eligible. And that will allow us for both you and the Commonwealth to give a little bit, some testimony. I'd like to hear some testimony on it. And the fact that he does have a work history interests me very much. We have so very few, I'd like to go into detail about his work history and that sort of thing. And I think that we'd be glad to take a look at. He doesn't seem like to be have that much of a criminal history at this juncture. So you just make sure you conduct yourself appropriately in corrections and work with your attorney to get this motion filed, and we'll consider it when it comes up to that. Okay? Okay. Thank you. Jenna Gregory. Jenna Gregory. Gino? Mistype on this. Are you Gino Gregory?
Sir,
What's your year of birth?
January 12th, 1996.
Last four digits of your social security number, 8808.
Yes.
You're here in 25 CR 0027 for sentencing. You have that pre-sentence investigation report. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty possession of controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 2 years, probated for 4 years, and shall enter the Monroe Specialty Court. Has he been?
He's been accepted, Your
Been accepted, okay. What are the court costs in this case?
165.
165. I will delay any payment on that until you're out for 30 days. You can pay $30, 30 days after you get into the drug court, $30 a month if that's paid, okay? Has he been voted in yet to the drug court? Okay, when can you do his orientation?
That I don't know. We'll have to find out from this.
Okay, well, I'll sign an order releasing you on the day you can do your orientation. Do you live here in Monroe County, Mr. Gregory? Well, I'll try to let you out enough so you can have somebody pick you up, bring you over here, let you clean up and stuff before you go to the drug court. I hope you make it through the drug court, man.
All ready.
Okay. William Miller, it says there's an active warrant out for William Miller. Do we have?
He's been transported, Judge. He has an active indictment.
Here he is.
He has an active indictment warrant that Rover wouldn't serve as far as we were made aware. So
Your Honor, it had been started.
the Commonwealth had him transported for the purpose of service and
Okay,
regular.
and has he been processed? Okay. Okay, I guess if you give me the file here. I'm gonna appoint public advocacy to represent Mr. Miller. I would say, Mr. Miller, you probably don't have, since you're incarcerated, you don't have the financial resources to hire him. Okay. Commonwealth versus William Miller, 25 CR 0025. You are William Miller.
Yes.
You were born in 1980.
Yes.
Last four digits of your social security number, 2359.
Yes.
You have the right to remain silent. You're represented by counsel. If anytime you have any questions, you can step away and ask your attorney. The grand jury of Monroe County has returned an indictment charging you with possession of controlled substance, first degree methamphetamine, giving a false identification to a police officer, failure to signal, and operating on revoked or suspended. Do you understand what those charges are?
Yes.
Okay. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
I'm signing a reciprocal discovery order right now, Mr. Miller, that requires the Commonwealth to give your attorney information to help you prepare for your defense. When is the negotiation day, Mr. Stockton?
It would be August the 8th at 9 o'clock.
Okay. I'm going to schedule you for August the 8th at 9 o'clock to be here for a negotiation day. And the next court date would be on August the 14th.
Thank you, Your Honor.
Give that to the officer there. Okay, Commonwealth versus Jody Murphy. Commonwealth versus Jody Murphy, 24 CR 0060. Are you Jody Murphy?
Sure.
Good morning. You born in 1999?
Yes, sir.
Last four digits, social security number 6590.
Yes, sir.
You're here today for sentencing. Have you had opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct?
Yes, sir.
Okay. Counselor, is there any reason why this person should not be sentenced today?
No, Your Honor, but I would like to make an argument for probation.
Please proceed.
I would like to take testimony, Your Honor.
Okay.
And Your Honor, I would like to call Ms. Bethany Steenberger and the alternative sentence worker with the public
Okay,
defender's
take it.
office.
Okay, you need to get the witness seat there. Okay, raise your right hand. You swear the testimony you're about to give is the truth, the whole truth. Have a seat, state who you are and what your position is.
My name is Bethany Steenberg and I work for the Glasgow Public Defender's Office as an alternative sentencing worker.
You may proceed.
Ms. Steenbergen, have you met with Ms. Murphy and assessed her situation?
I did.
Okay, and can you explain to the court, what it is that is going on with us?
So Miss Murphy is, I want to say around 22 weeks pregnant.
2 weeks and 2 days.
It's what?
She's 22 weeks pregnant.
Yeah.
Based off of her records that we've gotten from Dr. Craddock's office, she is a high-risk pregnancy. Because of,
You have those records with you?
I do not, they are with our investigator. I'm sorry.
Your Honor, I did submit to the court, last time a letter from Dr. Craddock's office. I believe if that is not in the court, I can provide that too, in the file. I can provide that. And actually, I do have a copy of what we obtained. I can go ahead and submit to the court.
Give it to Commonwealth to look at.
I believe
I think
that
I've seen,
it's
it's the same one she
Yeah.
furnished last month.
Yeah.
That's what I've seen.
Okay. That's his exhibit. Just give it over to, that's his exhibit 1 to the witness's testimony. Okay, go ahead.
Ms. Steenbergen, have you discussed with Ms. Murphy alternative to incarceration?
Yes.
And can you explain to the court what that is?
So I have obtained a bed letter for the Chrysalis House, which is a rehab facility for pregnant women in the state of Kentucky.
Can you explain what treatment looks like at the Chrysalis House?
So their program is in Lexington. It's right across the street from a delivery center. They are a 4 to 6 month program that allows women to return to the treatment program even after having the baby.
And is this a treatment facility for substance abuse?
Correct.
And would she be receiving counseling and other type of treatment for substance abuse while she is there and while she is pregnant?
Correct. Substance abuse, job readiness, parenting classes, and aftercare services.
And why do you believe that this is an appropriate alternative to incarceration for Ms. Murphy?
I don't think any baby deserves to be born in jail, but not just that, but the cost alone is substantial to our local agencies being a pregnant woman incarcerated. And I think that she deserves an opportunity, if you're having trouble with substance abuse, to get that help.
And who pays for her treatment at this facility?
Her insurance company would.
Okay, so it would not cost any.
Correct.
Okay. I have no further questions.
Did you say her insurance company, does she have private insurance?
No.
So it would be the government paying for it, whether the state of Kentucky pays for it or the federal government pays for it, the government's gonna be paying for her care.
Medicaid,
Wouldn't be our local taxes.
K-chip, probably.
That's probably right. I have no other
Well,
question.
you look at, I was looking at this report. It says nature of offense down at the bottom. I guess it says on 7/2/2020, the defendant appeared before the Clinton Circuit Court along with counsel. Is that a
No,
It's a mission.
no, her motion to revoke was heard in.
was heard in Clinton County?
Your Honor, we did that
So
for
actually it was heard in
We had a
Clinton
special
County,
hearing.
but Monroe Circuit Court. So it wasn't in front of Clinton Circuit Court, it's in front of Monroe Circuit Court meeting in Clinton County.
That's
Okay.
Yes. We had requested to be heard in Clinton County on this case
Yeah, okay.
for timing purposes.
Yeah.
I have no further questions for Ms. Steenbergen.
Do you have any questions for, you may send down. Do you have any other witnesses?
No, Your Honor, but I would like to make the argument.
Let Mr. Stockton see it. Do you have any witnesses, Mr. Stockton?
No, we put on the proof as to the revocation and when we were
You
sitting in
stand on
Clinton.
that.
I'm standing on that.
Okay, go ahead. You can make your argument.
Your Honor, I would ask for the court to probate Ms. Murphy. As the court has heard, she has significant reason to be probated and specifically to be sent to the treatment program. This would allow her to obtain help for substance abuse and also enable her to be able to receive the medical care that she needs.
I read, I'm aware of the letter and what, and your arguments are good, it's a good argument. But what gives me any level of confidence that if she's not revoked, that she won't get out and take drugs and hurt this baby?
Your Honor, that is what the treatment program would be for. I do think that one thing that was going on during the entirety of her pretrial diversion was instability, and this would allow her to become stable, which would also help her remain sober.
How far along is she?
22 weeks. So she's due in November, October.
So about the
November.
time she's eligible for shock probation would be about the time she's gonna have the baby, right? Is that right, Mr. Stockton?
She'd be eligible for shock in 30 days. So that's another 4 weeks. She'd only be about 27, 28 weeks.
Yeah.
She's still like a trimester.
Your Honor, I do have a concern with regard to Ms. Murphy and any continued medical visits that she would necessitate while in the Barron County Jail. Because she has been incarcerated for so long, she no longer has Medicaid, which means that it would be up to either the jail or DOC to pay for her medical.
Up to Monroe, she's a state prisoner, so wouldn't be up to the jail. It'd be up to Department of Corrections.
Not, but if she were in treatment, she would be able to get Medicaid back, and that would pay for it rather than DOC doing so.
Well, I don't see the difference between DOC and Medicaid paying for anything. It's out of one pocket. Both of them are, the only difference would be a portion of the Medicaid payment would be paid for by the federal government. But I appreciate your concern for the financial situation that the Commonwealth is in, but at this juncture, I just don't feel comfortable not incarcerating her. So, we'll take a look. If you get additional proof about her condition or want to have a hearing at some juncture on the motion for shock, I'll consider that. Okay. Thank you very much. Callie Strong. Callie Strong. Commonwealth versus Callie Strong, 22 CR 0061. Are you Callie Strong?
Yes.
Good morning. What were you born in 1969?
Yes, sir.
Last four digits of your social security number 2609?
No,
What is it? What are the last four digits?
7609.
76. Okay, we have a typo. 7609. Okay, you're here on 22 CR 0061, a pretrial diversion revocation. Now, Mr. Johnny Bell previously represented you. Is that correct?
Yes.
But now you're represented by public advocacy.
That's correct, Your Honor.
What does the Commonwealth have to say in this case as a pretrial diversion
If
revocation?
they want a hearing, I've got Mr. Graves' opinion. When he gets up here, we can have a hearing.
Your Honor, we're not asking for a hearing at this time. I've spoken with Mr. Strong. He wishes to stipulate to the violations and
Okay.
stand for vote today.
And what does the Commonwealth want to do? Tell me what the violation was, and since they've
Well,
stipulated.
he went into the specialty court because he tested positive for meth and marijuana. And I'm limited on my knowledge on the drug court violations because it says in the referral that he absconded from the program on 2/28/25, and he was in violation of the participation agreement that he signed on 12/17/24. That's one reason I subpoenaed Mr. Graves. Now, Deputy Richardson did tell me that when the warrant was in there, that Mr. Strong came and turned himself in, and he was clean at that time. Is that right?
Yeah, because he asked me to drug test because he said you want one.
Yeah. But that's all I know about the case. So.
Where's Mr. Graves?
I guess he's still in drug court. I've got a subpoena. He's supposed to be here as soon as he's available. Hmm?
So this is a pre-trial version.
So we should set it for sentence. He's here. Mr. Graves is here. He can.
This is a trial diversion revocation.
Yes.
Mr. Graves, you want to come around here? Let's talk about Mr. Strong just for a second. You raise your right hand. Swear the testimony about the gives the truth, whole truth, nothing but the truth. He is stipulated as to violation. Could you catch me up on exactly what happened to Mr. Strong? Do you remember? Yeah, he just didn't show up.
Called him, didn't get any answer. And so the judge issued a warrant.
Okay. Thank you very much. You're excused. I'm going to go ahead and revoke his pretrial diversion. Ask that pre-sentence investigation report be done by probation and parole with schedule sentencing for August the 14th, and any arguments that you might make, you can make then as far as probation is concerned, okay? Damian Tackett. Damian Tackett. Commonwealth versus Damian Tackett, 25 CR 0019. Are you Damian Tackett?
Yes.
Good morning. Were you born in 1984?
Yes.
Last four digits, social security number 4520.
Yes.
We're on a pretrial conference. What do we have?
We have a felony plea, Your Honor.
Okay. Ms. Tackett, I understand a motion has been tendered that says you wish to enter a guilty plea. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 25 CR 0019?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes, sir.
I'm going to go over them, and at the end, I'm going to ask you if you understand. You have a right not to testify against yourself. No one can make you say anything. Your right to speak, trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. Understand it, but in your guilty plea today, you give up all those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will review the pre-sentence investigation report done by probation and parole. In the event that after reviewing it, I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence on you, you have a right to withdraw your plea and proceed to trial. You understand that?
Yes, sir.
Mr. Stockton, are you going to present? Will you step to the left or step to your left over there? Listen very closely, sir, okay?
Upon a plea of guilty to criminal mischief first degree, the defendant shall receive a sentence of 5 years, probated for 5 years, supervised. He'll pay $1,592.47 restitution at the monthly rate of $100 per month, plus the clerk's fee, beginning 30 days after he has been released from incarceration. Each subsequent payment will be due each day thereafter, 30 days on the same month. He shall receive credit for time served, but be released upon final sentencing. He agrees all evidence will be destroyed and will obtain and maintain gainful employment.
Move back over here. Is that what you agreed to, sir?
Yes, sir.
Are you pleading because you did commit the acts charged in the indictment as amended?
Yes,
You plead guilty of your own free will.
yes, sir.
As I said, you had plenty of time to review this and you're satisfied with your attorney's representation.
Yes, sir.
Knowing your constitutional rights have extended to it, is it still your desire to proceed and allow the court to fix your punishment as permitted by law? Is that right? Okay. Is that your signature on the document?
Yes, sir.
You realize after entering this plea, any future convictions could be enhanced under the persistent felony offender law. Do you understand that?
Yes, sir.
I accept the agreement, order pre-sentence investigation report, schedule sentencing on August the 14th. Okay, thank you very much. Michael Vibert. Michael Vibert.
Okay, judging from the poll and your reactions in the comments, I think this is a court worth keeping an eye on. Again, I hadn't seen it prior to today. Now, it doesn't look like they're online often, like every couple of weeks, so I don't think this is going to be a daily driver for us, but I think we could visit them from time to time. Let's see what this guy's all about, and then soon we'll move on to another court.
Okay, we're here today on, says to enter a plea and on an arraignment on an information charge. Is that correct, Counselor?
Yes, Your Honor.
Okay, by information, just hold right there. By information, you're charged with 4 counts. On about the 30th, you're charged with fleeing and evading.
On the information, Jesse.
Yes, Your Honor. Be fleeing, evading, second's what he's pleading to. He'd be fleeing and
You're
evading.
charged with fleeing, evading, second, reckless driving, operating motor vehicle with expired license, and persistent felony offender first degree. That's what you've been arraigned for. You acknowledge receipt of the information,
Yes.
waive formal reading and arraignment. And now he's going to enter a guilty plea to some of those things. Is that correct?
Yes, Your Honor.
Okay. A motion's been tendered, says you wish to enter a plea today. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? You're the same person that we just identified in 25 CR 005 and 25 CR 0033. Is that correct?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in favor, right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. You understand that by entering this guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may plain range of sentence allowed by law. I don't have to accept it. Prior to accepting the recommendation, I would usually ask for a pre-sentence investigation report. However, because you're a state prisoner, that might be waived. Is that correct, Mr. Stockton?
Yes, sir.
Okay. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. If you'll step to your left there a little bit, sir, Mr. Stockton, come around and tell us what the Commonwealth's recommendation is.
Your Honor, in indictment 25 CR 5, Mr. Vilbert will plead guilty to wanton endangerment first degree, 3 counts, and persistent felony offender second degree, 3 counts, and receive a total of 10 years on each count to run concurrently for a total of 10 years. Also in 25 CR 5, he will plead guilty to the charge of fleeing or evading police first degree, a class C felony, and receive a sentence of 10 years. The 2 10-year sentences shall run concurrently for a total of 10 years in that indictment. In the information indictment 25 CR 33, he will plead guilty to fleeing and evading police second degree, receive a sentence of 5 years. The 10-year sentence in 25 CR 5 and 25 CR 33 shall run concurrently according to the Commonwealth's recommendation for a total of 10 years. The Commonwealth opposes probation and shock probation. He shall receive credit for time served.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you did commit those acts charged in the indictment as amended?
Yes, sir.
Of your own free will, knowing your constitutional rights is still your desire to proceed and allow the court to fix your punishment. You understand that any future convictions after entering this plea could be enhanced under a persistent felony offender. Is that your signature on the document?
Yes, sir.
I accept the agreement, waive pre-sentence investigation report, and will impose sentence. Can I get some help on this corrections department form where y'all fill in the point where it says what he pled guilty to? No, give it to the Commonwealth Attorney. So would y'all help us and fill that in there on what he pled guilty to? Because
They're gonna get all your.
it will not be necessary for him to come back for sentencing because I'm waiving the pre-sentence investigation report and putting the sentence on there today, okay? Okay, good luck to you, Mr. Bibber.
Thank you, sir.
I signed it.
You did sign it?
Yeah, so then, okay.
So, Michael, I think maybe we all just need a good night's sleep. When he was just off to the side of the lectern there, when the state was giving their spiel, I looked over at my screen, and it looked like there was a leash connected to that guy's handcuffs. And I was about to comment, is this guy on a leash? And then I looked closer, and it was one of Ellie's cat hairs that was on the screen. Speaking of which, hi, sweetheart. Was on the screen, perfectly placed so that it was connected to the end of his handcuffs, and it looked like a leash. I swear to God, I'm losing my mind. So we're all just a mess, I think. Let's switch it up. Let's go to Judge Boyd.
Morning, Your Honor.
Sometimes they're in work, she's working.
Judge has herself muted. We'll give it a second, see if that changes. If it doesn't, we'll move on to something else.
They were right in that assessment, but things were addressed, and I believe defense has brought things and will bring things to the court's attention.
Thank you.
Yes, what do you want to bring to my attention?
Judge, you're.
America, the land of medications.
From the VA, Judge.
Well, everybody needs to get a second opinion.
Yeah, my client, Mario Hernandez, Judge, dear friend of mine for many years, doing this pro bono rather. Mario is a U.S. veteran, saw combat, going through the VA for many things. Unfortunately,
Well, make sure you get a second opinion.
we'll deal with all the allegations of this case down the road, Judge. But unfortunately, there was an accident which caused.
No, I'm telling you, I am serious. I know sometimes that when you go to the VA, people are just accepting, but you should always get a second opinion. And I don't know why with the VA, it's as though you can't get a second opinion because you have to stay in that system. So just make sure you get a second opinion. Write your legislature, write your congressman to say, hey, I would like to get a second opinion because that's a lot of medications.
I think, why don't we just let him address the ankle monitor piece? I'm okay with him addressing it, Judge.
What is going on with the ankle monitor?
My foot, it gets swelled up. And then I can't really function.
As well as because of the diabetes?
Yes, and I'm diabetic, I have high blood pressure, sleep apnea, I mean, it's been bad.
All right, and so let me ask you this, and this is just for me to understand.
Yes, ma'am.
So the VA will give you medication, right? And then you'll have some sort of bad reaction to that medication, and then they'll give you some medication to take care of that.
Yes.
And then something else will happen with that, and then they'll give you more medication.
Yes, Your Honor.
But no, I'm very serious. Make sure that you get a second opinion.
I have been trying, Your Honor, and last time I talked to this, one of the pretrial officers about removing the.
No, I mean,
One
the
of the
second-
just to, so I can get MRI, my shoulders, and they couldn't do it. It's been.
Guess
I've been
what?
Dealing with this for 10 months.
Here's the thing about that. There's a legislator right here. He's your attorney. Say, hey, I want a second opinion. I need to get my shoulder. I still don't understand why, when people are trying to get appointments with the VA, it's months.
Yes.
And you're supposed to be in the military. You know, everybody wants to wave the flags. We love our military, but then it's not shown. So your legislator is here.
We need a promotion, Judge, to the United States Congress.
Yeah, you can talk to him and say, hey, I want to get a second opinion.
Yeah.
All right, I understand your issues that are going on, and I understand that when you have diabetes, that will skew any tests that you have for the alcohol. So I understand. With regards to the monitor, you have to be monitored some sort of way.
Yes, Your Honor, but like I said, I haven't had a problem with alcohol since the accident. I mean, since then, I haven't touched anything. I'm not doing anything wrong.
No, I
I'm trying
understand.
to work and I can even work.
Here's the thing, I understand what you're saying, but legally, the law says, and he will tell you, the law says you must be monitored by some sort of alcohol device. So what you need to do is speak with your pretrial services officer, and I will send them an email also if there's no objection, and let them know what all of your issues are, and let them know if there is some other device that they can recommend for you. And if there is another device, I think now they may have started the wristwatch or something, or the blow. So talk to your pretrial services officer, see if they have something that's in your price range. And then your attorney can speak with the state and see if they have any objections to it. If the state has no objection to it and you're being monitored, I have no problem signing it, okay?
Thank you, Judge. And Judge, just to be clear, the reason he was on the ankle monitor for some time, he wasn't driving at all because of the injuries that had occurred during that accident. So possibly we'll talk to pretrial, as you suggested,
Yeah.
see if we could get placed on it in ignition and all of it.
Yes.
Because he's not, I know him
Yeah.
very well.
Yes, so if you contact them and I'll take that matter up. And you all are about to go in session again?
Monday, yeah.
Yes, all right. And how long do you think this session will last? You have any idea?
They're 30-day sessions, Judge, but unfortunately our illustrious governor has added redistricting, so if things don't go well, they'll call it again and again and again like they did last time.
All right, so Ms. Ferguson, what I'll do, I'll set this in 35 days approximately, and then we'll see where we are.
Yes, Judge. And if I need to file is that I wanted to come in. I didn't want to file a legislative continuance right now because I didn't really need it from the start to.
All right.
I'm allowed to, but I didn't want to do that. I wanted to come in and address this with Mr. Hernandez. And to come see you, because it's been.
It's always good seeing you. All right, so we're gonna bring you back on August 21st. Once you sign the reset form, you're excused, okay?
Okay.
Thank you.
All right, thank you. And again, second opinions, it should be standard for you're allowed to get a second opinion and even get a second opinion outside the system. But the only way you can do that, I've discovered, is you should write your legislature, email your congressman or whoever that is, and tell them, hey, tell them, hey, I want to get a second opinion and my appointment needs to be now. It can't be 4 months, 5 months in the future.
That's correct. Yeah, because I was in the emergency room last month for my shoulders. And I don't have an appointment with primary until September 20th.
Because my thing is either we love our troops or we don't. It's nice for TV to say you love your troops, and what are you doing? All right, sir, once you just have a seat, thank you for dressing appropriately for court. They're going to give your attorney the reset form. Once you sign the reset form, you're excused. And I will send that email to pretrial services.
Thank you.
All right.
Appreciate it.
Thank you.
Excuse me.
Yes. Sherry Dye. And Tiana Chessman.
Yes, Your Honor.
All right, this is this family violence? All right, so there's a motion to travel, is this correct?
Yes, Your Honor.
Are you ready to proceed?
We're ready.
All right, the court is calling NIMAG number 756623, State versus Tiana Cheeseman. Can I have parties announced for the record for the state,
Rick Daniel for the state of Texas.
for the defense?
Carrie Dye on behalf of Tiana Cheeseman. I'm present. She's present. We're ready.
Are you Ms. Cheeseman?
Yes, I am Mrs. Cheeseman.
All right. So it's a court's understanding defense that you would like for her to be able to travel. Is that correct?
That's correct, Your Honor.
And this case has not been indicted. Is that correct?
That's correct.
And how long has this case been pending, state?
Fine.
Do you have an offense date?
Yes, I'm trying to get that for you. Looks like it's been pending for a little over a year, March 20th, 2024.
All right, this has been pending since March 2024, over a year. So state, do you have any objections to her traveling?
At this time, yes, given the nature of the charge, the facts that are involved with the charge, the injuries that the child sustained from this defendant. And unfortunately, given the fact that at this time we can't confirm for sure the whereabouts of the child, we would object to this.
All right, and state, I know you're not in charge of indictments or tendering cases to the grand jury for indictment, but this hasn't been tendered to the grand jury in over a year?
That's correct.
All right. So Ms. Cheeseman, can you raise your right hand for me, please?
Yes,
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes,
You can lower your hand, state your name for the record.
Tiana Cheeseman.
All right, Ms. Cheeseman, the complainant in this case is a child?
It is, yes, sir.
Okay. Have you had contact with the child?
Yes,
All right, has the child been placed back with you?
yes, with supervision.
And is that supervision through Child Protective Services?
No, everything with Child Protective Services was closed out as of October of 2024.
Okay. So we were here on August 1st, 2024. The case still had not been indicted. And there was an agreement that the defendant was to have no unsupervised contact with minor children. And she has not violated that. She's still having supervised contact. So state, do you have any proof or evidence that she's having unsupervised contact?
At the moment, Your Honor.
All right, so where would you like to travel?
So I was supposed to be traveling to New Orleans, but that trip has now expired. Next will either be Dallas, Fort Worth, Texas, or in Houston.
All right, and what would be the travel permit? What is the purpose of the travel?
Medical conferences, because I'm a nurse.
All right. Anything else from either side?
Yes, Your Honor. I would just like to offer to the court. I did provide Prosecutor Ashley, I apologize, her last name is escaping me. I did provide her with a certificate of completion of my client's parenting class and a closure letter from the CPS caseworker. I personally, as an officer of the court, will represent. I spoke with the caseworker. She had no concerns about Ms. Cheeseman. And stated that it was her understanding that her husband would be there. I'm not sure why the state is saying they can't confirm the whereabouts of the child, that the home has remained the same for the child the entire time.
All right, this is what the court is going to do. The court will allow the defendant to travel for purposes of medical conferences or her employment. The court will note that the Child Protective Services case has been closed, and there's to be continued no unsupervised contact with minors. Is there anything else?
Your Honor, the court did grant my client the ability to perform the duties under her job when she sees children for work purposes. That was addressed previously in this court.
And the work purposes with regards to employment?
She's a nurse.
All right, but she's a nurse that she is supervised by other doctors, correct?
Yes, Your Honor.
Is that correct, Ms. Cheeseman?
Yes, yes, it is.
And the doctors are aware of this offense?
No.
All right. So she needs to be supervised by doctors, and they need to know the fact that she has this pending case, because she's a nurse, and it should, according to licensing, this is something that should be told to her employer.
And Your Honor,
In state, this has been pending for a year.
I will
So-
have with intake today, so they can do as close to top close as they can to present.
All right, and counsel, you want to say something?
yes, Your Honor. Ms. Jackson was the previous prosecutor on this case and had not given those directives or instructions, and we were trying to work out something prior to her departure from the office. And so I made Ashley aware of that today so that hopefully we could work out some resolution in this matter.
Ashley Jones for the record, Your Honor.
Yes.
Just for the court clarification, at the last bond hearing on August 1st of 2024, I did go back and review that, and the court did allow the defendant to still continue to protect the children at her job. And so at this time, the state's not asking for any different orders other than that prior hearing.
Well, she needs to be supervised, and my understanding is that her employment, she's supervised by doctors.
Yes, sir.
All right. All right, is there anything else?
Nothing from the state.
Anything else, counsel?
Nothing further.
All right, thank you.
All right, thank you.
Thank you. Have a good day.
You too.
Okay, let's head back to Judge McNally's court and we'll round out our day with him.
That's correct, Your Honor, yes.
That charge of overweight, responsible or not responsible?
Responsible.
I'll accept the plea, $1,200, pay by August 15th. Is that the only one you have?
Yeah, that's it, Your Honor.
Thank you. Have a good day.
Thanks,
Gonzalez.
Appreciate it.
Sonia Adalia Gonzalez Corona, file 25B148788A. Good morning.
Good morning, Your Honor.
Your appearance?
Evelyn, the rules certified court interpreter.
Okay, nice to have you here.
Thank you, Your Honor.
I'm going to ask you to raise your right hand. You solemnly swear or affirm that you'll make a true and accurate translation between the court and the defendant.
Yes, I do.
Can you tell me your name, please, ma'am?
¿Y usted, señora, puede por favor dejarme saber su nombre? Sonia Idalia González Corona. Sonia Idalia González Corona.
You are charged with violation of instructional permit.
Y usted han acusado de que hubo una violación del permiso de conducir. Sí.
You have the right to a lawyer.
Usted tiene derecho de tener un abogado.
I'll be happy to give you one today.
Y yo con mucho gusto que le daré un abogado de persuasión.
Would you like a lawyer to represent you?
Abogado para representarla a usted. Do I need one?
It's up to you. You probably should get one.
Probablemente usted debería tenerlo. Okay.
I'm not saying you're going to jail or anything, but they can certainly help you.
No estoy diciendo búsqueda voy a mandar a la cárcel, algo semejante, pero no todo el mundo puede ayudar.
Okay?
I agree then.
So we'll send you to a lawyer, and either way, you're coming back in front of me, okay?
La vamos a mandar, que tenga una reunión, un abogado defensor, y de todos modos, regresan a
Thank you.
Yeah.
Thanks.
You're right.
Rana Group LLC, 25B82635, 25B82613, 25B82612. What is your name, ma'am?
Rana Matar.
Nice and loud.
Rana Matar.
What is your position with that company?
Landlord resident.
Okay, so let me explain something to you. Corporations really need a lawyer, okay? This is a corporation. I have no issue with you pre-trying this or having a pre-formal hearing on this, but if you're gonna contest it, I really have to have you get a lawyer, okay?
Okay, I didn't know what I need to do.
Well, it's a corporation, and technically I can't allow you to engage in the unauthorized practice of law. Not technically, I just can't. So I don't have a problem on a civil infraction, underline that. I don't have a problem allowing the president to appear and work it out, but if you can't work it out and it's a contested hearing, I can't really let you practice law here. So you're gonna have to have a lawyer. I'll schedule it for a formal hearing, but you have to get a lawyer, okay?
Okay.
All right, Lisa, set formal, and you're gonna have to move quick, okay? Set formal for,
August 13th at 9 o'clock.
I don't have a docket on any of these until then, huh?
Well, you do. It's just less than 2 weeks.
All right, August 13th at 9 o'clock, okay, ma'am?
Okay.
Any questions? Any questions?
I was asking her,
Who?
like what, Caitlin?
Yeah,
Like what are the fees that she could pay, tell me anything?
well, this isn't a payable misdemeanor. These are rental registration. You have to have your rental property registered with the township.
Hate to cut in, but I know you're going out the door here. So, Barbara, I wanted to say thank you for gifting the membership. Very thoughtful of you, and I appreciate it. Go enjoy time with your family, and if we don't see you tomorrow, that means you're really enjoying time with your family. So I hope we don't see you tomorrow, but take care, and thanks again.
My time, this is what I do.
Okay.
This is what we're here for.
Okay.
But you have to have your rental property registered, and it looks like you haven't been successful in that. Okay?
Well, this is their story, right?
Well, I'm not saying they're right.
Yeah.
I'm not saying any of
That's what
that.
I'm saying, that's their story. They're paid for, but they don't want to do the inspection for that more. It's a story that we need to hear it for.
The one of these citations said you failed on
Yes, and they will not come to re-inspect
multiple failed inspections. Multiple failed inspections.
because they couldn't go in. The tenant will not open the door. That I don't have a tenant there anymore, so they can go.
Better get a lawyer, okay? I mean, if you guys want to go in, if you want to go in and talk to her again and see if you can resolve it, that's fine. I'm gonna be here all day, so if you want to go in and talk to her, feel free.
To the city?
No, to the prosecutor.
Where you were in the jury room.
Yeah, but she said we can't resolve, get this resolution. And that's what I don't understand. There's something I'm missing here.
I don't know what to tell you. It says multiple failed inspections, so they must have been out there. They wouldn't write that on a ticket, I don't think.
They couldn't go in. Yeah. I'll try to talk to her again, but she said we can resolve it, so you probably want to get here.
Okay, well, that's what I'm scheduling it for, but if you go back and talk to her and you guys resolve it, she can bring the files back in, okay? Thank you. Kenneth?
Michael, thank you for gifting a membership, and yes, it landed on the perfect name for a membership you would gift. We'll leave it with the birds today, since you guys have been enjoying the nature scenes the last couple of days. I appreciate y'all being here today. I hope that you all had fun. I did. I like the fact that we got to see a new court, and it was pretty okay. That's a judge I'm going to keep an eye on. Seems to run a good court. You could hear everything there, so that was a nice treat, because so often that's so difficult, because production value is definitely a secondary consideration in these places. But yeah, we'll see you all tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members, as always. I hope you all have a great Thursday, and see you tomorrow. Take care. God bless.